Let's see. This is the 22. Yes, at page 19. Yes. But you should detail. This is quite a.
Yes, Your Lordship. The recent action taken is also with us. We'll enclose that also, Your Lordship.
Well, like they say, the first toothbrush you use as a child, the toothbrush, the plastic toothbrush, the first toothbrush you use is still somewhere. It'll be there now. Maybe you 50 years down the line, but the first toothbrush you use will be stuck
somewhere in some.
It'll still be there.
Yes, my lord.
Yes. On the MSTI submits that the affidavit would not yet be filed, as there have been as instructions as the what
additional instructions have been received.
Instructions have been received, which need to be incorporated in the affidavit. Stop. Next, similarly, Mr. Philemon Longbrief for the respondents number.
Number 2 minute.
Huh?
Number 2.
Please submit. Please you allowed 2 weeks time for filing affidavit. This is a matter of 2 weeks for affidavit by the respondents.
My lord.
Oblige, Your Lordship.
Item number 5.
Dr. Saraf, okay. Dr. Saraf, your items already been posted for hearing after 3 weeks. Interim order to continue.
Lord, be grateful, my lord.
Yes.
My lord.
You have taken up the first item.
No, number 5.
Yes.
Here, what happened was this is arising out of Customs Act.
Yes.
They filed a writ petition.
Your lordship, the petitioner has initially challenged the order of confiscation of gold and.
But you have recourse to statutory remedy.
Yes, your lordship, but your lordship, initially he had filed a writ before Honorable High Court of Rajasthan.
Yes.
So initially the petitioner has challenged the order of confiscation before the Honorable High Court of Rajasthan. And after some time it was decided that the Honorable High Court had no jurisdiction to try the instant writ petition over there. So as per the direction of the Honorable High Court of Rajasthan, the petitioner has approached the Honorable Court here. So initially objection was raised by the respondent side that regarding the maintainability of the instant petition, your lordship. So on the last occasion, submission was made that affidavit will be filed from the respondent side challenging the maintainability of the.
Is it necessary to file affidavit, Dr. Mojika? When was the confiscation done?
My lord, if I may take your lordship to the Rajasthan High Court order, my lord.
Where is that?
Page 331, my lord. Confiscation is of 1997.
331.
331.
This is the order of Commissioner Customs.
331, page 331.
331. 331.
My lord.
No, 331 is the.
I go to Judicature Rajasthan at Jodhpur.
The 3-page numbers in 1 page. 61 is not here. What's 61? Where's the Madhya Pradesh? This is all. Dr. Pushpendra Singh Bhatti.
My lord.
That is page 356. As per our copy, right? 356.
But they have given to me 331. my lord.
Why you not made the pagination correctly?
Your Lordship, I'll rectify these 8 pages.
At least you, the
Yes, sir.
one you give to your. Yes.
So, my lord, the writ petition was pending in Rajasthan High Court since 2002, my lord.
1002.
My lord, after 22 years, it was disposed of on 21/3/24 on the ground of territorial jurisdiction, my lord.
What remains now?
Lordship,
Both
I
the
may
kids
be
were never.
I may be allowed to seek instruction if on the next date, if possible, I'll withdraw with liberty to file it fresh, Your Lordship, with the custom appeal.
But then the thing is that now it's 1996.
Yes, Your Lordship. Almost 12 years where the said writ was pending before the Honorable Rajasthan High Court. So,
Yes. You want to take instructions?
yes, Your Lordship.
Yes, as a challenge to the maintainability of the incident petition have been made by the respondent, by the customs respondents 2 and 3. Learned counsel for the petitioner. That we allowed to obtain instructions. You are B. Sharma, no?
A. Joshi.
Sorry. The conservation basically allowed to obtain instruction for release the matter after 3 weeks.
3 weeks, Lordship. Declare pledge.
Item number 6.
In this particular matter. First of all, my profuse apology for appearing virtually. I had boarded the flight at 4 o'clock. Flight got
Perfectly all right, yes.
Yes, my lord. This, my lord, is a second round of litigation. My lord recalls on the first round of litigation, I had come before my lord against the show cause notice, primarily on the ground that show cause notice was based
We
on
have to file our objection, my Lord. I pray for 2 weeks' time, my Lord.
Who are you?
Lord,
For the state, my Lord.
Lord, we are pressing for an interim stay in this matter. The matter had come up last on 14th of August. Their lordships were pleased to issue the notice and listed today for stay hearing. I have a 102 crore demand, and if any stay is not there, I face a threat of recovery, and therefore, my lord may consider my interim prayer today. That's my request.
Let us file our objection, my Lord. My Lord, the petition also, my Lord, it's very thick. It's almost.
It all, my lord,
over a month to read it.
My Lord, we just pray only 2 weeks' time, my Lord. We'll file our objection and let there be hearing thereafter.
Only
may I
or entire matter.
We can do hearing on the entire matter because I'll be filing my objection as we get to the main petition.
What is the ground challenge here?
Yes, my lord. May I explain? If my lord takes
Yes.
page 523 of volume 1 of my petition,
Yes.
my lord,
523.
523. May I read that?
Volume 1.
Yes.
523 is not volume 1.
Volume annexure 33,
Annexure
the
30. Page.
page 523.
Second one.
Second
Volume. Yes. 523. Second volume. 523.
Yes. It's my lord's
Yes.
My lord's order dated 11th of December 23 where I had appeared. I'll just read out. The writ petitioner by way of instant writ petition is assailing a demand con show cause notice bearing number so-and-so and date so-and-so, dated so-and-so, which has been issued by respondent number 4 under section 74 of the CGST Act and 74 of Meghalaya. The challenge has been made on the ground that the said show cause notice is illegal and without jurisdiction inasmuch as the demand for GST on annuity received by the petitioner from National Highway Authority has been made in contradiction and violation of an exemption to annuity granted under notification so-and-so, 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 so-and-so. Further challenge has also been made to a circular dated so-and-so issued by the respondent number 3 as well as the recommendation of the respondent number 6 in the 43rd GST Council held on so-and-so. The circular has been impugned in as much as the same is based on memorandum of recommendation dated so-and-so, which had clarified that dated 23A of the exemption notification does not exempt GST on annuity paid for construction of road, which in turn was the basis for on which the impugned show cause notice dated so-and-so has been issued. It has been contended by the counsel for the petitioner that in spite of the demand being unjustified and against the very grain of the exemption notification, respondents have, by way of show cause notice, demonstrated their stand so as to issue in question. Attention of this court has been drawn to the communication dated so-and-so addressed to so-and-so, which was made in response to summon under Section 70, wherein petitioner elaborated the decision of the council to exempt annuity of tax payment. The impugned show cause notice which is submitted is therefore misplaced or uncalled for. The learned counsel has further argued that the filing of a response to the impugned show cause notice in view of the firm stand taken by the respondents will be but a futile exercise, with the outcome having already been determined by the respondents. It has been further submitted that the Karnataka High Court, in case of so-and-so, by judgment dated so-and-so, has held that impugned circular dated so-and-so to be bad in law, and that the same has been set aside. As such, it submits to relegate the petitioner to undergo proceedings before respondent would be of no consequence, and that in view of the circumstances as they pertain, interference of this court is called for to set aside and quash the impugned circular as well as the show cause notice dated so-and-so. Mr. Mozika, learned DSG, assisted by so-and-so learned counsel for the respondent in this short submission, has argued, notwithstanding the prevailing situation or circumstances, especially the fact that the impugned circular has since been set aside by the Karnataka High Court, a ruling which the respondents are bound to take consideration. The issue has not been predetermined or inflexible stand taken as regards to the impugned circular to not warrant a response to the show cause notice. He therefore submits that the matter being still yet to be decided, writ petition is premature and not liable to be entered by this court at this stage. Considering the submission made by the parties around perusal of the material as placed before this court, it is seen that the writ petition has come against a show cause notice issued under Section 74 CGST Red Way corresponding in Meghalaya, wherein the petitioner has to show cause within 30 days as to why stated amount of GST allegedly short paid on annuity payment received along with interest and penalty be not realized. This para 8 is very relevant. Petitioner, it appears, instead of responding to the show cause notice, have chosen to assail the same as has been discussed above. No doubt the writ petitioner cannot be said to be devoid of merit. My lords have stated so. But at this stage, wherein final orders are yet to be passed by the respondents in the matter, and further with the submission of the respondent that the matter is yet to be considered finally, this court at this stage, without further going into the merits, is not inclined to interfere in the instant writ petition. Therefore, my lords had said that it is premature, the same is disposed of, and liberty was given. I must also disclose, we went to the Supreme Court against this order. Their lordships have endorsed my lord's view and said that please go and show the Karnataka High Court judgment. We hope that the authorities would also take cognizance of that. That judgment, my lord, will find at page 530 of the Honorable Supreme Court. This is more for disclosure. Page 530.
Yeah.
This is the order dated 5th of February 24. We have heard the letter of Mr. So-and-so for the petitioner. We disposed of this SLP by reiterating what has been observed by the High Court with the modification that the time to file the reply shall now be extended up to so. The reply to the impugned show cause notice shall be given by the petitioner along with the necessary documents and the orders passed by the other high courts vis-a-vis circular of the respondent department. So this Karnataka High Court judgment that we have been seeking to rely upon, Supreme Court said, please go and show it to them. And my lords had also reposed faith in the adjudicating authority, as also the Supreme Court, that they will certainly look into that, the fact that the order has been, that circular has been quashed. Now, when the matter came back before the Honorable Learned Commissioner, we pleaded so. Now, a definitive view, what we apprehended has become a reality. The judgment has been dealt with by the Learned Commissioner, which my lord will find at page 123, para 4.17. It is rather unfortunate that the casual manner, 123. In the most casual manner, he deals with it. Yes, para 4.17. In reply dated so-and-so, the notice quoted various appeals in different courts claiming that wide order dated so-and-so in the case of so-and-so versus Union of India, Honorable Karnataka High Court has declared the circular number so-and-so but bad in law, as it had the overriding effect on notification so-and-so. However, the notice here have failed to mention that in the same order dated 11/7/22, the High Court of Karnataka also held that nothing prevents the department from imposing GST on the consideration paid to concessioner, like the notice on the payment received by them by way of annuity, but that has to be done in a manner known to law, because the High Court was actually telling them there are other ways in which you could have done, not in the manner. And I'll show that particular paragraph. Then the next point, para 4.18. Notice he further failed to mention that none of the appeals, including the case of Karnataka, have attained finality, and all the appeals are still pending before the Honorable Court still date. So therefore, he says that because there is an appeal pending, there is no stay, he doesn't want to rely upon that. Now, what the High Court had said, which they have been completely misconstrued, the Lord will find at page 584, para 14. This is exactly what the High Court said.
584.
Yes, my Lord. 534. I'm so sorry, my Lord. 534.
The other volume. Other volume.
Volume.
Yeah.
Volume 2. Yes, I'm so sorry.
That's all right.
This is the, yes. Karnataka High Court, the judgment that we have been seeking to rely upon, how it has been dealt with, para 14. May I read?
Yes.
As stated above, the deliberation of the GST Council in its meeting held on so-and-so and the notification issued pursuant thereto clearly exempts the entire annuity being paid to petitioners towards construction and maintenance of road. It cannot be construed to have not exempted the annuity deferred payments towards construction of the roads. The impugned circular has the effect of overriding the notification bearing number so-and-so dated so-and-so and has to be held as bad in law. Nothing prevents respondent number 1 from imposing GST on the transaction paid to concessioners like the petitioners on payment received by them by way of annuity, but that has to be done in a manner known to law, which means that you can't do it through a circular, you have to do it through an amendment. In the instant case, respondent number 1 has issued the notification under section 11 of the CGST Act and section 6 of the IGST Act, exempting the consideration received by concession from highway authorities as annuity from GST. The clarification issues is contrary to the said notification for the reason recorded above. If respondent number 1 is desire of altering the same, it has to issue a fresh notification amending its earlier notification. That is what the Karnataka High Court said. They did not say that this circular is good and you can be carried out. So therefore, my lord, what has happened is our apprehension has become a reality. My lords had imposed faith in the adjudicant authority, but they seem to have continued to do the same line as was there. That is one, my lord. Now, may I request, my lord, the circular basis which we are seeking to make this case, kindly have section 11.3 of section 11.3 of the CGST Act, which my lord will find at section page 6.
1 second. Yeah.
Section 11.3, which my lord will find at, if my lord are looking at the book, then my lord, section 11 is the power to grant exemption from tax.
Yes.
Where the government is satisfied that it is necessary in the public interest so to do, it may on the recommendation of the council by notification exempt generally, either absolutely or subject to such condition as may be specified therein, goods or services or both of any specified description from the whole or any of the tax leviable thereon, with effect from such dates as may be specified in such notification. Where the government is satisfied that it is necessary in the public interest so to do, it may on the recommendation of the council by special order in each case under circumstances of exceptional nature to be stated in such order, exempt from payment of tax any goods or services or both on which tax is leviable. Now, 3 is relevant. The government may, if it considers necessary or expedient so to do for the purpose of clarifying the scope or applicability of any notification issued under subsection 1 or order issued under subsection 2, insert an explanation in such notification and order as the case may be by notification at any time within 1 year of issue of the notification under subsection 1 or order under subsection 2, and every such explanation shall have the effect as if it had always been the part of the first such notification or order as the case may be. In other words, 11.3 confers power on the government to clarify the scope of a notification, whereas in the present, and that too it has to happen within 1 year. Whereas in the present case, the clarification to the notification has come about by CBSE, which my lord will find at page 158. And they have no jurisdiction to do so, and that too the clarification comes after 4 years.
Yes, Dr. Muzika.
I'm still awaiting instructions, madam.
Will it give you 1 week's time? We'll have it for, at least for you file some sort of objection, then we'll take it up interim orders. Otherwise, we'll stay the circular.
My lord,
before my lord, here,
No, because the total days you have to explain this, how this orders come about, because it's total like misunderstanding, or I don't understand how they comprehend it.
my lord, here there was a notification, that is notification dated 28th June 2017, that is the central tax rate, and thereafter, my lord, a notifications, my lord, that is 13th October 2017, that has come, and my lord, by this notification, my lord, by these notifications, the notification number 32 of 2017, they have included the provision that is 23A, which says service by way of access to a road or a bridge on payment of annuity. Means this is an exemption notification, my lord, as regard to the service. Now, by this notification, they are basing on this notification, they are saying that because the annuity is exempted under this notification, so they have to be exempted from tax liability. But that is not the case, because, my lord, as per this section, as per this provision 23A, my lord, this is applicable only in cases where there is a service that is provided by way of access to a road or a bridge on payment of annuity. If they are collecting toll, that is by way of access to a road or a bridge, only in that event, if they are paid because of their collection, if they are paid annuity, only in that event, my lord, the exemptions is applicable. But here it is totally related to construction service, my lord. That is as per, there is a
You put an affidavit after, you wouldn't one week.
that is why, my lord, because
Yes.
this is what they are praying, my lord, this has not been exempted, my lord. And my lord,
You'll examine it after 1 week. You are paying for respondent number.
But I'm paying for 2 weeks, my lord. But the
Why?
instruction has to come
we
from
require at least 2
GST
weeks, my
Council.
lord.
You're paying for respondent number 3-4. You are paying for
I'm appearing for 2, my lord.
2, and Dr. Mozika for tax. What about the GST Council?
Except GST Council.
Notice has to go, my lord, to GST Council.
No, but notice has not already gone.
Noted.
When was the matter moved? Lord,
When was it taken up on first instance?
first hearing, 11th of December.
11 May.
It was in May.
Order of 15 July, my lord.
15 July.
Notice of was returnable by 7th.
Fourteenth of July.
Yeah, but they received notice also. So well and good. Yes, today on the matters taken up for consideration, the learned counsel for the respondents number, the Dr. Mozika counsel for the respondent number
1, 3, 4, and 5.
1, 3, 4, and 5, and Mr. N. Simcon for the respondent number 2.
Yes.
Have agreed that be given some more time to file their affidavits or objections to the prayers as made out in the objection stop. Mr. Sujit Ghosh, the senior counsel, on behalf of the petitioner, has raised strong objections. Submitted the matter has been pending still, has been instituted since and
15 July.
since May or July.
15 July.
15 to
15
July.
July. Whereas it may as the objections. Whereas it may, in view of the issue of objection that have been raised in all submissions, it is directed that the affidavit be in place
2 weeks time.
within 2 weeks. Yes, for continuing interim prayers. Respondent number 6 of notice indicates that the notice has duly been served. Respondent number 6, but no appearance made on their behalf today. Accordingly,
May I pray that until then some amount of limited protection be given, because the
Yeah,
regular
If
is
the
like
matter is coming after 2 weeks, my lord, let there be proper hearing thereafter, my lord.
till the next date, no course of action shall be taken against the.
I'm so blessed. I'm so blessed. 30th September, my lord, may keep it on 30th September, subject convenience. 30th.
Fine, is 30th September.
I'm so
No,
blessed.
30th September, We'll have it on the 1st of October better.
1st of October.
Yes.
Very
Yes.
well. I'm sorry.
Obliged.
You put in your objection.
Yes.
But could it be on 3rd October, my lord? I'm so sorry.
Okay, 3rd October. 3rd October.
3rd October. I'm so blessed.
Obliged.
It's up. Any mention?
May I please, Your Lordship, I beg to mention item number 19.
Number?
19, 19, Your Lordship. I pray for 2 weeks' time, Your Lordship.
I'm appearing for respondent number 4 to 8, Your Lordship.
Who's for the state? Oh, JGDC. No objection. Will never objection. When?
After 2 weeks, Your Lordship.
Okay. Yes.
Similar prayer,
No, Your Lordship.
Yes.
similar prayer with item 26, Your Lordship.
Number?
26, 26.
26. No objection.
No objection, Your Lordship.
What's the matter about? School teacher?
Your Lordship, yes.
The school teacher matters.
Not school teachers, Your Lordship. It's
In
about,
service or out of service?
no, this is about the 18 months DLED versus the 2
They
years.
have challenged the selection process and the appointment of the private respondent, Your Lordship.
After?
After 2 weeks, Your Lordship.
Yes.
Apply.
Much obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20, Your Lordship. I am pray that this matter be taken after 2 weeks.
What's the matter about?
This is regarding appointment, Your Lordship, where the this
Appointment to what? To teacher?
no, Your Lordship, where the has
Compassionate appointment? Okay, 2 weeks.
similar prayer for item number 25, Your Lordship.
Again, exhausting my list. Mangkolan, who for Nehu?
My lord, this is the case on last occasion, my lord. This is the matter of selection, appointment of a private respondent number 6 is under challenge. In the meantime, what happened? I have filed my affidavit. In the meantime, what happened? He was on VN. His substantive post was in Tamil Nadu University. He has resigned. We have accepted the resignation.
Then what remains?
If they want for academic purpose, my lord, I am ready. Why he is being delayed? I don't know.
The instruction, Your Lordship. I am
Last time, lordship has given the
I
time.
want a petitioner here. Who's the Dr. Mangkolan Singh son? He's from Shillong.
no, Your Lordship.
And where is he from?
He stay outside, Your Lordship.
He stays outside.
Yes, outside Meghalaya, Your Lordship.
I have the copy of the order.
Examine it, yes.
2 weeks, Your
You
Lordship.
won't keep dead wood, yes.
2 weeks, Your
No,
Lordship.
no, dead wood. You won't keep dead wood hanging around in the list. Yes.
I have the copy of the
And
order.
you'll be there. We'll call it, we'll just examine it.
Lordship can
No, Your
take on
Lordship,
records the
because
copy of the order.
I don't have the instruction, Your Lordship.
Doesn't matter. The court
Let it
has
come on
happens. Before the court has decided.
Let it come on Monday, Your Lordship, then.
We'll pick it up, yes, 25. You wait, yes.
Yes, Your Lordship.
Maybe it's Lordship. Item number 22, madam.
Yes.
And for the state. Madam, on the last occasion, the court had put a query regarding the applicability of the rules, Meghalaya Secretariat.
What
So
rules?
I'm yet to get the instruction.
This is a matter, Your Lordship. In the last question, we did the hearing, and Your Lordship have questioned the state whether the Meghalaya Secretariat.
How it is.
Yes, yes. How is it applicable?
Well, I've yet to get the
My own
instruction.
school.
I'll yet to get the instruction. I need some time.
You already were given 1 week's time.
No, no.
How far is it from
No, madam.
Secretariat to here?
I need to get some more time. 2 weeks, sir.
There's a daftari post, correct?
Yes, Your Lordship.
Lordship, there was concern also raising regarding the pay or skill pay. The level in the metrics of pay.
Well, what is the pay matrix? That's the only thing. That'll define what
Madam.
kind of post is, whether it's grade 3 or grade 4 post.
Madam.
That already point out, Your Lordship, regarding the one of the office memorandum 1986. That's clause 4.1, subclause 4. Your Lordship have already point out, Your Lordship, in the last occasion that the post of doctorate is fall within the category of grade 4, Your Lordship.
Anyway, 1 more week.
No, no, no.
Mr. A. Khan raised for further 1 week's time to obtain instructions as to the applicability of the rules. Secretariat service rules. Yes, to the service of the petitioner. Yes, a list up to 1 week.
Lordship, let the matter be taken up positively. I'm the senior most in the career list, the gradation list, Lordship. So,
you already been promoted, correct?
Already.
yes, Lordship.
Then what is your grievance?
The matter of release of pay also is still pending, Lordship, pendency of this.
Why not getting paid?
way of getting, Your Lordship, but not in accordance with the scale that I'm supposed to.
You'll get your arrears, but you're occupying that post now, correct?
Yes, Lordship.
No, Your Lordship. He's not
You're not
applying. No. As per the affidavit of the respondent number 5, also in para 17, of all these stated that the post is still lying vacant till date, Your Lordship.
No, you get instructions quickly.
Yes, Your Lordship. If required, Lordship, I'll be allowed to file it.
You can file, no problem. Any material which will help in education, no problem. But don't delay the matter.
Yes, Lordship. But I'll oblige.
Oblige, Lordship.
Please, Your Lordship, I beg to make a mention of item number 21, Your Lordship. I pray this matter may be taken up after 2 weeks, Your Lordship.
George Charleston was mine.
No objection, Your Lordship.
No urgency.
Your Lordship, after 1 week.
No urgency with 3 weeks.
Your Lordship, after 2 weeks, Your Lordship.
Okay, 2 weeks, yes.
Highly obliged.
Yes.
May I please, Your Lordship, I beg to mention item number 15, Lordship. Conducting counsel is out of station. After 1 week, Lordship.
Number?
15, Lordship.
What's the matter about? Small matter.
Yes, Your Lordship, regarding stepping up of pay.
Then, where's Mr. P.T. Sama?
Out of station, Lordship. After 1 week.
2 weeks, yes.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 23, Your Lordship.
Number?
23, Your Lordship. As the senior conducting counsel is not well, Your Lordship.
Where's Mr. Yubin?
Mr.
Yeah,
Yubin is at the courtroom, my lord.
Here for a petitioner?
Yes.
We have informed them, Your Lordship.
How long? 3
After
weeks.
2 weeks. 3 weeks.
Take
I live
3
night.
weeks.
2 weeks, my lord, would be enough.
You're a petitioner?
3 weeks.
Yes, my lord.
Oh, it'll be okay, 2 weeks, yes.
Much
I thought
I
he's a
live-
petitioner.
Supplementary list, item number 1.
Lordship, I'm appearing on behalf of Mr. Chanda. It's not available today.
But any interim prayer?
No, Lordship.
Then?
Lordship, Lordship, they are-
Yes, the third, Mr. ML Nampur, issue notice, Mr. Dr. Mozika is present except on behalf of all the respondents. No one was required just after 3 weeks. Anything else?
Lordship.
Well,
Obliged.
the affidavit, yes.
Item number 2.
Please, Lordship. Let's,
We already heard the matter substantially yesterday.
my lords, I am informed, my lords. I apologize for my
No, it's all right. You're not
non-availability
well.
yesterday.
How will you redeem the situation?
Well, it's two aspects, if I may just bring to your Lordship's kind
Ombudsman
notice.
is there. for the
I'm sorry.
And Ombudsman is there.
Ombudsman is there, my lords, but this entire exercise takes, my lords, donkey's years. In this case, especially, my lords, that once the money is retrieved, then, my lords, making a debit without informing the customer, my lords, I do not know how that is permissible under law. That's one. Then subsequently, when I write to them, my lords, they say that it is under some consideration. And again, when we write to them, they said that they need some time to, my lords, decide on this issue. The fact of the matter remains, my lords, there is an FIR lodged. On the basis of the FIR, you stop the money, you retrieve the money. If it was not retrieved, it is a different issue, my lords. Once you've retrieved the money, then again making a further debit on my account without my knowledge, my lords, is absolutely impermissible.
Then
in law.
the amount has gone to that person in Delhi.
My lords, we don't know. Because if the bank was able to retrieve it, my lords, they must have acted on some advice from somewhere. Because my account got credited with that amount, my lords. I had that amount back in my account. Now, subsequently, my lords, that amount is again debited by the bank at the instance of the bank.
Which bank? Which branch?
This is the HDFC Bank, my lords.
Which branch is this?
I think this is the Shillong branch. Police Bazaar, Shillong branch, my lords.
Mr. Sinkon, you're waiting for the bank.
Something seems amiss here, my lords.
I'm appearing for the statement.
No, yes, we'll issue notice. Because it cannot be. I mean, okay, fine, if we can understand the money is lost in the bank and retrieved, but if it's been retrieved, and again by O2 sweep is taken out.
Somewhere, my lords, these banks also have to be a little more responsible.
Yeah.
The other thing, my lords, which I wanted to humbly submit before Lordships, that this is becoming a regular feature, my lords. Almost everybody in and around
getting scammed.
Is scammed on these ways. Now, one of the difficulties that is being faced by one and everyone, my lords, is that the first response is somebody goes and files an FIR with a local police station. Now, obviously, the local police station is not in a position to deal with it, so they refer the matter to the cyber cell. But in this entire process, what happens is that the money has probably changed into another 10 different accounts. So, if some kind of an SOP, since the state is also a party, and we are before your lordship.
That will have to have a proper hearing, because this kind of a cybercrime Hydra head, it's called like that. Once it becomes Hydra headed kind of.
It's become a Hydra-headed snake, we don't know how to tackle it anymore.
You won't know where, you won't know where it is, because in just in the blink of an eye.
Lordship.
It's gone. It's
So if there is some mechanism which is put into place, where there is one desk, from where there can be some coordination between the banks and the police, as well as the police of the all other states.
Bank on board first. Was this call made? VoIP.
It was a WhatsApp call.
The call that the way scam.
Regular phone call,
Regular call.
Not a voice or internet.
No. Every day we are faced with something new keeps coming up.
No, but because according to where's S. Barachaji, he's not here.
She's here.
She said that the voice was of that of Mrs. Dillal only. That is the. I can understand if it's a text message, where you ask for OTP and you send it, that kind of thing. Yes, you get scammed, the money goes and you retrieve it. But she said it's his voice.
It is his voice.
That's why I have transferred your lordship. Otherwise, I would not.
So there's a local
and I
paper
have started sending screenshot of my this debit credited debit.
What is very alarming is in most of these cases, these scammers seem to have some internal input regarding where the weakness, where the person would be vulnerable to being scammed.
I've been my number was cloned also, my picture and everything that went to the registry, the officers telling me to buy Amazon gift cards, that I am stuck somewhere, I can't get back to court right now. So can you just buy this gift card so and so? The moment I get back, I'll refund it to you. I'll show it to me. And the thing is that they got the number of the deputy registrar and assistant registrar. But at that time, one had been transferred. So he said, hello, what are you doing? It was by name, I'm here, can you just buy a gift card? I'll just reimburse it to you. I'm just out right now. And the message is so genuine, and in the first name basis. But it so happened it was given to the number of the assistant registrar. By that time, they just been transferred, so a new person was in place. So got this message. And it happened even in the old CS's name also. Then, you heard about that. 2-3 people here, they bought us gift cards.
Little while earlier, the Chief Justice of India was making requests to everybody to purchase gift cards.
No, I'm stuck in Connaught Place. That kind of thing. So even in my name, it's gone. So what are you going to do?
Well, which is why I say
the registry. They think that a judge he's somewhere stuck somewhere.
And sometimes it's because people don't. Coming from that kind of a person, there's no question of doubting it. Probably there's some difficulty.
If we don't do it, if we come back to court, they'll get,
Which is why I humbly submit before your lordships that some kind of SOP or mechanism needs to put into place.
And the number anyway was from Kazakhstan. That number, imagine.
Well, that's because they make it bounce to
VoIP,
VoIP. Yes, that's how they do it. But if the state can come up with this, we can put up a mechanism, and it can be a role mechanism for even the rest of the country. Because this kind of, I think half the people sitting in this courtroom, my lord, must have been a victim of some kind of scam. Some must have got away with it, Millets. And some people, Millets, have suffered. There have been instances of people in Shillong, Millets, whose entire life savings have been taken away.
So people of you who travel out to other cities also be very careful about the Uber app now.
Yes, sir.
What's happened, it just happened to a family friend. So, you book a ride, then a number comes, even if you haven't booked a ride, then it comes like, you book this cab with a number so and so. And when you press it, the ride starts happening, and you're still sitting at home. Then you cancel it, then the voice comes, sorry, the mistake. But then the bills come to 112, it's already been deducted from your account. So what we'll do is we refund it, sorry, we take a note with, your complaint and all. So then they've got the name and say, okay, fine. When you get OTP, just share it with us and we'll refund this money to you. And when this poor lady thinks she's getting the 112 rupees back, he gives the OTP, 5 lakhs gone.
The entire account is cleaned up.
Anyway, yes.
My lord, let the notice go, my lord, to respondent number 4 and
But
5.
Mr. K. Paul, Senior Counsel, with so and so, issue notice. The incident petition has been brought for the court. Complaining about the chain of events that have taken place with regard to a scam that has been detected, but however, thereafter, in spite of retrieval of the amount stated to have been the amount which stated have been debited from the petitioner's account being retrieved, the same was again debited without instructions or without notice to the petitioner.
Well, that is available at page 40, my lords, Annexure 10.
40.
That's the statement, my lords.
Yes.
The last two entries, my lords, if your lordships kindly have a look.
This fact is evidenced by the extract of the saving account details statement for the dates 28/2024, when the said amount was deposited, redeposited on 28, right?
My lords.
No, 22-0.
No, 28, yes, certainly 28 was deposit. But however, on 27/8/2024, again stood debited in said account. The instant issue has become like a plague in this age of internet banking, and this court takes serious notice of the same. Then notice issue to as Mr. N. Sinkon is present on behalf of the state respondent 1, 2, 3, then notice issue to the
4 and 5.
respondents 4 and 5 within 2 days from today, just after 1 week.
Lordship, I grant us liberty to serve thus the minutes.
Yes, liberty granted the petitioner to effect service
Obliged.
on the private respondent.
Item number 3.
This is that matter, my lords. This time we've been a little more careful.
Yes.
This matter, my lords, we had to withdraw this matter because there were some defects.
Yeah.
Here the simple issue is, my lords, that the members of the managing committee are themselves alleging that some jobs have been offered for...
You file a proper one.
I'm sorry.
This is a fresh petition.
This is a fresh petition, my lords. We had withdrawn the earlier. Your lordships had allowed us to withdraw it.
Yes.
So let notice issue, my lords, to all the respondents.
Yes, Mr. Shulai.
Let notice go.
Right, Mr. K. Policy Counsel, assisted by Mr. S. Kappa. To notice, Mr. N.D. Shulai led the AAG.
1, 2, 3, your lordship.
Present, except for 1, 2, 3. That notice issued to the remaining respondents within 3 days.
4 to 7, my lords.
Yes.
Apply.
3 weeks.
Daily list item number 1.
Was it for today?
Previously, it was listed for admission hearing, my lord, and your lordships had heard. But due to paucity of time, your lordships could not pass the order. Today, it has to be, it's again fixed for admission hearing, my lord.
Anything else submit, Mr. Bora? What's the matter about?
My lord, a matter for substitution and restoration of a title suit which was dismissed for default.
22 said.
My case, my lord, is that my father expired on.
No, we know about that.
Yeah,
But anything in regard to what is this? Your delay of how many days?
Yes, my lord. That the petition which was filed on 20th March, that was a petition filed for substitution of the plaintiff.
Without condemnation application.
Under Order 22, Rule 3.
Without condemnation application.
That is on page 59 of the main petition.
Yes.
Then there, well, in the court, I was informed by the presiding officer of the subordinate district council court that the case was dismissed for default under Order 9, Rule 8. So I was allowed to write there in the cause title, read with Order 9, Rule 9 for CPC for restoration. The court allowed me to write, so I wrote it there. And I was also allowed to...
So only one thing, okay. Now forget about the nature of the case.
So, my lord,
the thing is that, see, your case is an appealable case, appealable order, correct? Then why have you come to 227?
It's not an appealable order.
See, it is an appealable order. You have gone before the judge.
No, I have come against the dismissal order on revision.
Exactly.
And the dismissal, what happened?
Order dismissed for default.
The Order 9, Rule 9 actually did not apply. Ultimately, the petition was dismissed because Order 9, Rule 9 did not apply and there was no condemnation petition. That was the result of this petition. Now, my humble submission is that this petition...
illegality has been committed or irregularity by the court, trial court, that you've come back to 227.
The mistake started from that point. On
why you come back to 227? What correction do you expect from this court? Which cannot be done by a judge?
We come to the fact that on the date when the case was dismissed for default, the plaintiff was not alive. So that order was a nullity. On the date of the order of dismissal for default.
See, you did not appear. So
that order happens to be against a dead person. That is why that order is a nullity. And then the date when it was dismissed for default was not fixed for any hearing. So Order 9, Rule 9 will not come into application. So Section 151 will come into application for any petition, and the limitation period for that is 3 years. And as per the calculation, I am late by 1,086 days, which is less than 3 years.
You invoke Order 9, Rule 9, correct?
Because I was led to the mistake. That was the mistake. We had gone, both parties were under the mistake that there was an order under Order 9, Rule 9. But it was not even order under Order 9, Rule 9, because it was not fixed for hearing. So that order of the court below was also under Section 151 CPC only.
So tell the court now, what kind of order do you expect from the 227?
Well, that the order which is nullity may be declared as a nullity.
How do you think whatever happened right from trial court can be corrected by the court at this stage? You have even gone and appealed to the judge. What do you think can be corrected?
What I pray is that the order which is nullity should be declared a nullity and the case should proceed thereafter.
So you're seeking with one stone to kill 3-4 birds?
Yes,
your condemnation, your substitution,
as the fact,
then your
I'm late by 1,086 days.
You have not filed a condemnation application, also substitution?
I'm late by 1,086 days, and 3 years is made by 1,095 days, my lord.
So that means
I'm
that
still within the
one
limitation,
stroke,
actually.
If I set aside the order of the trial court, that means it revives everything.
Yes, because of the mistake that both parties were under the impression that the order of dismissal for default was an order under Order 9, Rule 8 CPC, and proceeded till 2022 after COVID. Whereas that order was not under Order 9, Rule 8, it was an order under 151 CPC. And the order of dismissal for default is a nullity. So that should be declared a nullity, and the title should proceed thereafter. So from the order of declaration, I'll get 30 days to go for
So
substitution.
you filed substitution, correct?
I went for
filed-
substitution
you
initially
filed-
without
you
knowing
filed
that
it.
it was dismissed.
You'd already filed it, but then when you filed substitution, you never filed a coronation application along with that.
Did not file for any restoration because I did not
Why?
know on that date. On that date when I went for substitution because I didn't know that case was dismissed. And the court had informed me that case was dismissed, and I was allowed to endorse this order and rule 9 there, making me believe that the dismissal order was under order 9 rule 8. So I was under mistake and proceeded under mistake till 2022 when the case was ultimately dismissed. Thereafter, I have filed this revision, urging the court to pass an order declaring that order which was passed against a dead person as a nullity, and let the title suit proceed thereafter.
I'm sorry, Mr. Bora. Let's see the order. It doesn't matter to me. Where's the order? Which here. That order of which you see that on the next. With the main case, please.
Page 58 is the handwritten orders.
1 second.
And page 57 is the typed order. Plaintiff absent, defendants present, through counsel. Now case stands dismissed for default.
Yes, period after term. This is an order under order 9 rule 8. Fine. When the defendant only appears. Yes.
It seems like order 9 rule, an order under order 9 rule 8, but previous dates.
Come to the early order.
Case was not fixed for hearing.
You were absent. You absent.
3rd May.
All along.
Since April 2017, when the hearing was there.
You never went one post.
Never went, and my father fell sick. He was paralyzed, and his counsel thought that he is going for an appeal, so his counsel gave the brief and went about his own business.
Then you went and filed an application under order 22 substitution, correct?
For substitution, yes.
Yes, and then you added by hand with.
I was allowed to add by the court by hand. Order 9 rule 9
for restoration.
And also in the prayer also I was allowed. In the court only I wrote.
Totally is not informed. So after your father died, you didn't care to consult a lawyer also?
Actually, I was not aware.
You know, aware of father's death or not aware of the suit?
I was aware of father's death, but I was not aware of the status of the case. When I met my father's counsel on the way, I came to know that I have to substitute. So immediately I went for substitution.
Even substitution, my lord, under order 22, rule 3, there has to be an application explaining the delay, my lord.
That was the application filed on 28th March.
See, one thing.
Where I was allowed to add order 9 to.
If we are to say, the thing is that now, if you take order 8, rule 8, okay, now it's been dismissed and absent defendant. Now, if you take order 9, rule 9, it bars you bring a fresh suit. Now, this order is final. Then it's an appealable order. It should be filed with. Why did you should have filed it for the judge?
My humble submission is that this order is not under order 9
You
rule
didn't
8.
come to know that should be taken into consideration. When did you come to know, is it, that the suit is pending? The suit be dismissed for default?
No, my humble
When you filed this application on
20th March 2018.
You filed it on
20 March
2018, right? That was a few months after.
That was 189 days.
Fine.
late, yes.
Then why? Anyway, that's besides the point. Why did you file an appeal against the order 12/9/17?
I couldn't get.
Why against the order of dismissal? Then you didn't. If it's gone beyond.
I didn't know about the dismissal at that time.
Fine, but then you got to know about 18, correct?
No, when I go.
And 18, you went to substitute yourself only.
I went for substitution, knowing that my father is dead, and I should substitute.
You didn't
And
know
when I go to the court, I came to know that
the
case was
it
dismissed.
had been dismissed for default.
I came to
That means when you file an application, substitution, and also you added that for restoration, you did not see that in the order sheet with dismissal for default.
Yes, my lord, I went for substitution first.
Then after you got told, then you filed.
Because I didn't know about the dismissal. When I came to know, I had not seen, I was told that it is dismissed for default, so I was allowed to endorse there on the petition or the main rule line, and also add a line for restoration in the prayer. So the mistake started from there,
Why
that
does this court
believing
also
that
help you?
it is an order
Why does
under
the
order
court
line
also
rule
help
8.
you and also the litigants, but in the phase of the records,
I tried to present this before, but then this petition was pending, COVID came, there was no court, and immediately after passing the order, this presiding officer was
COVID came
promoted.
2 years after that.
There was no court for 5 years. Srimati Week India was promoted immediately after passing of this order, and that court was vacant till Ms. Salam was appointed in 2022. Then she took up the matter and passed the order.
Now, since that has been invoked, order has been passed, he has to go and file an appeal.
I had gone for substitution initially. Then I came to know from the council that I have to substitute my
Where's the
father is dead.
coordination application along the substitution application?
That's what the
That's what meaning.
the petition I filed was for substitution initially.
How will we correct this thing? Because whoever's suffering here is
Only that all I pray for is that the order passed on 12/9/17 should be declared nullity because it was
yes,
passed
if
against
one
a
declared
death person.
nullity by
When it
one
becomes a
stroke of
nullity,
pen,
the case
for all the
proceeds.
latches and lapses that you have committed in the entire proceedings now 17
So
now,
there is no
for 7 years
dismissal.
you want to be washed away without any just washed away without any repercussions.
Since the order is under 151 CPC, I get 3 years time, and I have filed it within 3 years time.
You want to put in the 12/9/17, which is out of the question.
No, my humble submission is that since the order is not under Order 9 Rule 8, it is an order under 151 CPC, the limitation period should be 3 years, and my petition
How do you
for
have one under 151?
condonation is within,
Why did
petition
you
is
under
within
151?
limitation period, actually.
Why is it under 151?
Because there is no provision for dismissing a case when case is not fixed for hearing, not even under Order 17 or Order 18. It must be fixed for hearing, then only if there is absence, case can be dismissed for default. When there is no provision and a case has been dismissed, that means the inherent power has been invoked to dismiss the case.
You should have come within time.
Because there is no provision.
Would I have a judgment on alternative remedy, my lord?
I've been relying on that Kerala High Court judgment only. That
Lord, Kerala High Court is totally different, my lord. In that matter, the court was in knowledge that the plaintiff had was since deceased. In this case,
another judgment also I wanted to present of our own High Court that the case was not fixed for hearing.
There's
So
a
Order 9
from
Rule
this
9
bench only. Where
yes,
that when it's from Garwil, where it's not fixed for, that is on a different. Yes, which paragraph?
Lord, para 17, 18 and 19, my lord.
Very difficult, Mr. Bora. This is the conduct of how the case is conducted. Because 227 will not arise. And by setting aside the order doesn't mean that that you it's a very smart move, no doubt. By 227 you show that
very
it's
smart.
very
My humble submission is that when this order is,
you never challenge it before the appellate court. If you
there was no opportunity, there will be res judicata because the matter was already pending in the court. There was no presiding officer. I couldn't go anywhere else because of res judicata.
Which paragraph?
Lord, 17, 18 and 19, my lord. Alternative remedy, my lord.
Sorry, we'll pass orders.
Oblige.
You can't take advantage, to say
still
that this
insist
court
that
interferes with one order.
this
which
order
will
may
wipe
be
out all your indiscretion
declared nullity.
and all the that is should go on appeal.
Lord,
If you think it's a nullity, go and appeal for the judge and say that it's an order 151, it's not fixed for hearing on that day, and the case is for default.
Assuming that order is set aside, my lord, still abatement comes in place, my lord.
So when this order is set aside as a nullity, there is no
We'll pass
dismissal.
Item number 2.
Yes, Mr.
Lordship, I'm praying if this matter can be taken up after 2 weeks, Lordship.
Another court.
Lordship, after 2 weeks, Lordship. Learned Senior has some difficulty, Lordship. Today, Lordship.
He's not well.
No objection.
You also given up
No, well, we are pursuing the matter in the trial court. There's no stay here.
after 2 weeks. As the arguing senior counsel state to be unwell. Yes.
Obliged, my lord.
Item number 3.
Yes.
Lordship, the grievance of the petitioner was that there was a non-compliance of your Lordship's order, which is at page 19 of the contempt application, page 9 of the contempt application, order dated 4/7/23.
Yeah.
There was some dispute with regard to who the money, the compensation should be paid to. Your Lordship's direction is contained at page 12, paras 7.
Yeah. Yes.
So they were directed to file a 64 application, which would be disposed of within 4 months, preferably. They filed their application on the 13th of July 23. This does not really indicate that they want a reference, but we have now construed this to be a reference application, and we filed a show cause note indicating that we have already passed an order for reference on the 20th of August 24. There has been some delay.
Yes, Your Lordship, but Your Lordship, at first instance, when we approached before Your Lordship by way of writ, we were never, my name was never reflected in the list. So upon filing before Your Lordship in the writ petition, then my name came out, Your Lordship, and I was directed to file an application under Section 64 of the Land Acquisition 2013 Act. And Your Lordship, I was made to wait, Your Lordship, and in accordance with the affidavit of the respondent, she made a statement that she's on election duty and all. Yes, Your Lordship, but however, the fact is that the matter of how it was sent for reference was that no compensation was paid to me, and I have never even received whatever so amount, Your Lordship. So how can any application would lie to the appropriate authority under Section 64 when I have not even received a single penny? Otherwise, whatever reference made to the appropriate authority under Section 64, Your Lordship, there should be certain amount which I have received, and then that should be determined by the appropriate authority. However, now, Your Lordship, I have not received any.
I don't get your submission. Now the thing is that it's gone under Section 64 asking you because there's a dispute as to get the compensation, correct?
Yes, Your Lordship.
Then-
Your Lordship, at first instance, before the petition, Your Lordship, that Pital Ranga he has received, Your Lordship. So ultimately, during the
from him. Where's that? He's not party here.
he's not a party, Your Lordship. But Your Lordship, in accordance with the proceedings before the respondents, Your Lordship, there has been admission made that my land has been acquired and payment of money will be made. So now that has not been made, Your Lordship. But however, later, Your Lordship, upon receipt of the copy from the respondent, Lordship, I came to know of the amount that I should receive.
Leave it. They filed it on 13/7. 23. Thank you. What happens in such cases, Mr. Sensensi? Like you one that is accepted by the collector that his land has been taken 54 meters, correct?
Gotcha.
And the money has been paid. So how do you resolve the situation?
So well, there was that issue, which is why Lordships had taken into consideration both the competing claims and directed the aggrieved parties to approach the DC under Section 64. So they did file an application on the 13th of July. There is no actual prayer for reference, but we treated this as an application for reference and we made the reference order. I understand Lordship's query is that what happens if the money is paid to somebody else? That would essentially be a civil dispute, my lord, for recovery. But in the meantime, if your Lordship will kindly have my affidavit.
2013.
If your Lordship will kindly have my affidavit.
One second. Yes. Yes.
The affidavit filed on 29th of August 24. So pursuant to Lordship's order, a meeting was called for, which is the minutes are at page 7.
See, fine, because 64 application, whatever, this is like a finding.
Lordship.
Yes, a finding. Now, how do you compensate them now?
No, which is why I'm coming to that application.
Yes.
Can you see page 7? We've had a meeting and we've assured them that the money would be paid, and thereafter a request has been made for placement of funds.
Now, who will recover the money from this battle?
Not in respect of that, which is why we've also written
to recover.
Well,
do you institute proceedings by the collector himself?
I'm not sure how they will proceed for recovery.
Proceedings.
I'm not really sure. I'll have to take instructions. But kindly see, after this meeting held on the 17th of August 23, kindly come to page 10. This is a letter dated 29th of February 24.
Yes.
This is a request for placement of funds, and kindly see serial number 1.
Yes.
Serial numbers 1 to 6 are the names of left out landowners in the earlier approved LA list for the construction of Indo-Bangladesh border fencing within so and so. And kindly then see the last paragraph. So we've indicated a list of all the people who've been left out, and we've requested for placement of funds amounting to about 5 crores.
Left out is different and wrongful payment is different.
Yes, I understand. Yes. So their name for this particular stretch is indicated in this page, page 11, serial number 1, whole Conglear.
Right.
So some amount of money is due to her.
54 million shown here, but the fact remains that this money you pay to someone else.
Yes, so then for that they'll have to recover the money in whatever means they
recover the money.
I'll take instructions, my lord. This is what the DC has undertaken this exercise.
But see, there's no contempt as such, Mr. Lingdor, because they've taken steps. Meeting was held on 17th. You put in an application on 13th July, correct?
Yes,
and
Lord.
then they've already cited, yes, your land's been taken 52 meters. So, 52 meters, so you have to be compensated.
Yes, Your Lordship. In accordance with Lordship, the order passed by Your Lordship. I was directed, Your Lordship, I complied with the entire.
Now they've already said that
but
you are due. But the only thing is that they are waiting for placement of funds.
Lordship. So in parallel, there are two proceedings.
But Your Lordship, the manner of how the decision was taken when they filed the affidavit, it was learned that they have filed for reference before the appropriate authority. Now, Your Lordship, in accordance with Section 64 of the Act, Lordship would say, any person interested who has not accepted the award by written application to declare require the matter be referred to the collector for determination of the authority as the case may be, where there is objection be to the measurement of the land, the amount of the compensation, the person who was paid.
Section 65 cover this.
If not, then it will be treated as 76 minutes. Can you see 76?
65 won't cover.
So 76
I think
in
it's
that
the
case.
wrong reference.
We just complied with Lordship's direction. It can be treated as something as under 76 minutes.
Lordship, because at first...
No. His case will be different. His case is on a totally different footing. Now, the only thing that we can say up to the point of placement, like asking for fund, it's all right. He'll get his money. But referring it under Section 65, whether... No. $76 was 76.
Disputes as to apportionment.
Yes. So whose authority to decide that?
Again, the DC.
The DC refers
because the claims will be before the DC.
Before the DC refers to itself.
No, not to the DC. DC, in case the DC finds there are two competing claims or a case is made out under 76, they'll refer it to the special authority.
Who's the special authority?
The court, my lord. So if it's not treated under 64, it can be treated as one under 76. So both are references.
But in
eventually.
contempt, we can't pass. Anyway, we'll close the contempt for now.
But Your Lordship,
We'll close the contempt. See, the thing is that there's no willful violation. Contempt is limited to that.
Your Lordship, there has been like a clear admission from the part of.
No, we're not on facts of the case anymore, Mr. Lingdor.
Your Lordship, yes.
You're only saying that they violated orders of this court. Now you've seen they're not violated. They've gone ahead. They've had a meeting. You have filed your application. They had a meeting. They accept your contention. They said it's been wrongly paid. That amount also has been fixed. That you're to be paid the amount. Only thing now is to wait for it. But
Yes,
only thing wrong they've done is under referring on 65 this one.
Your Lordship, the petitioner is very
You're
old.
free to file a fresh petition. We can address.
But in any case, Manoj,
But Your Lordship, what matters involved here, Your Lordship, is the legality of the application of the section and the reference.
But that
Your Lordship, basically,
in contempt, we can't. An affidavit has been filed by the state respondents indicating the fact that on an application filed by the petitioner, the matter was taken up for consideration. But on an application filed by the petitioner on 13/7/2023, pursuant to the order of this court dated
4/7/23.
4/7/23, the matter was taken up by the Deputy Commissioner of Revenue, wherein it was accepted that for a length of land compensation for 54 meters, which should have been paid, which have been awarded to the petitioner, which have been due to the petitioner, was instead given to one Sri Pital Ranga. Stop. The matter was then the affidavit also shows that the matter has then proceeded thereafter, and thereby letter dated 29/3/2024, a request has been made for placement of funds to pay the compensation of the petitioner amongst others in the list as appended. However, a side issue has arisen with regard to the reference by the collector of the matter under section 65.
64.
64. Which does not seem to be the correct position to settle the matter, as it involves only the manner of, what do you call it, apportioning the compensation. As this court sitting contempt jurisdiction, the only duty of the court is to see whether there's any willful violation of the orders of this court. From the perusal of material shows that there's been no willful violation. As such, no contempt lies, and this seems closed. You file your petition.
Item number 4.
Early obliged.
My Lord, this is the contempt matter. We are appearing for number 1. Chief.
Bishop 2, 3, 4 are yet to appear.
My Lord, we keep me.
Yeah, they've applied. You appeal for 2, 3, 4.
Appearing for respondent number 2, 3, and 4.
Why did you file affidavit, Mr. Changreso?
My Lord, if Lordship give us some time for filing a show cause.
I collecting the tolls now.
Lordship.
He's happy. Yes.
After the contempt petition, Lordship, I could go there and
Enjoying now, collecting the tolls.
not enjoy it. Lordship.
Yes.
Collecting the tolls.
Mr. Changreso, your name, sorry?
Ms. Kir Khan,
Kira Khamdi, yes.
under the senior counsel.
Who has entered appearance today on behalf of respondents 2, 3, and 4. You want to file affidavit or no?
We'll file it.
She prays for allowed 2 weeks time to file affidavit. Stop. Make para similar prayers made by Mr. H.L. Chandu, senior counsel, on behalf of respondent number 1. Prayers allowed this up to 2 weeks before the orders.
Kind of like.
Much obliged.
Item number 5.
My lord, this is in this case, my lord. My lord, chief has directed to release my pension subject to the production of succession certificate, lordship. In the process, it was also directed to the respondent to give the details, lordship. But I have communicated the order to the department, and department have not given any details, lordship. Then I filed in this case for modification of the order, saying that since because my deceased husband did not leave anything except the family pension, lordship. So during the course at the motion hearing, lordship, my lordship has orally directed the Union of India to provide the details, lordship, so that at least I can obtain the succession certificate. If there is no details, because they are not accepting any application without any details, lordship. At least if they can furnish any details, at least I can approach to the concerned authority and can obtain the succession certificate, lordship.
So, you got the details now?
No, my lordship.
13,500 per month.
My lord, that is only now if they give some sort 1 year or 2 year, any area, lordship.
What areas? You're entitled to since when do you think you're entitled?
2020, lord.
2020. So
Yes.
13,500 per month, you calculate.
My lord, they will not accept, lordship. That also I have.
Who not accept?
That district council, lordship. They want that orders, lordship, at least 1 year or 2 year, any details, lordship. That with effect from so also, that is the area, lordship.
What details did you give him?
My lord will kindly see that orders, lordship.
What's in other courts?
Page 7, lordship. My lord, page 7, lordship. In the order, page 7, lordship. Page 7, paragraph 5, lordship, page 8 is the direction, lordship. Paragraph 5, page 8.
Yes.
It is further noted that though the claim seemed bona fide, the absence of any document showing the date of his first wife has resulted the family pension not being granted to the petitioner. In this view of the matter, it would be in the interest of justice that the petitioner be directed to approach the competent court to obtain certificate for the retirement benefits, including the family pension which is due. The respondents are directed to provide the information necessary with regard to the amount of family pension payable.
Amount of pension payable means monthly or the entire amount?
Entire, lordship.
Yes, MSK Guru, you supply the detail.
Down, lordship, it is expected the respondents will supply all the details expeditiously.
You have not supplied till now.
No, lordship, they have only in the last order they have mentioned that I am entitled to get 13,500 per month as a pension. Now, if they give the area also, at least I can show it to the department.
With this lordship, lordship, Dr. and Muzika, lordship, the learned DJ is on legacy, lordship.
They delayed the matter maybe at the end of the
board, lordship.
end of the board, lordship.
Which department is this?
This is
BSF,
lordship.
Item number 6.
Lord, in this case, some changes are there in the affidavit, my lord. So I'm praying for a week's time. In fact, the E. Mairang was here yesterday, my lord.
Yeah?
The executive engineer.
Me?
The executive engineer Mairang was here yesterday, my lord.
So what can I do? What it is?
So, my lord, some changes have been made. And my lord, there is the new CE is supposed to join the post, my lord. So I'm praying for a week's time.
Mr. Kivas is expert in avoiding to file affidavit within time.
No, my lord, because in response to para... No, my lord, I will specify.
An art of perfected it.
No, Lord, in response to para 13 and 14, my lord, some changes were there.
After it's been, since when? Since May.
May, my lord.
1 week's time granted to the government respond to file affidavit. Is thereafter.
Obliged, my lord.
7.
Yes.
My lord, as per the last order, my lord,
Yes.
This is the matter of the benefit of ACP and MACP to the cipher category, my lord.
It's covered by the judgment of 1st May, Dr. Mozika.
I'm praying for 1 week time to file affidavit.
Why?
We'll file an affidavit. In fact, it is in the process, my lord. Within 1 week.
It doesn't cover.
This is the covered matter, my lord. Kindly see page number 111, my lord.
It comes next week, my lord. Can be disposed of.
Next week they'll come after pujas. Then before Christmas, after Christmas. So happens all the cases. Yes. 111.
Yes, my lord.
Just to ascertain whether these petitions are there in that list or not. We have prepared a list of 1,050 people, my lord, for grant of benefit. I just want to ascertain whether their names are there in that list. Then the matter can be disposed of.
No, because at that time also, he said the board officer screening cipher category personnel for grant ECP and MCP has already been convened.
Well, the petitioners in that case were included in the list, my lord.
This 1050 list.
My lord.
No.
Petitioners here.
Petitioners in the earlier case were not included. The petitioners in the present case, my lord.
They're not included in the list of 1050.
I'm not very sure about that, my lord. It comes on next week, my lord. I'll just verify that and the matter can be disposed.
How many prisoners are here, Mr. Kumar?
8, I think.
How many?
8 petitioners.
3 only. No, how many are many?
18 of them.
18.
My lord, 18, my lord. Yes, my lord.
Though it has been submitted that the judgment of this court dated 1/5/2024, the case of the petitioners with regard to grant of ACP and MACP. Yes, Dr. N. Mozika prays that he may be allowed some time to examine the same, as the number of personnel entitled under the same consideration is numbering about 150.
1,050.
1050. So, list after 1 week. Yes.
Item number 8.
If the name is not there, what will happen? It will be covered. It will be covered. Yes.
DPR, your lordship.
Yes.
Lordship, in this case, I'm filing my affidavit during the course of the day.
Very good. Where's MS EB Pata? You're not filing?
Instruction, but instruction were incomplete. Praying for additional 2 weeks, Your Lordship.
For 1 week.
2 weeks, Your Lordship.
Your Lordship, actually in this case, the petitioner is suffering, Your Lordship. So
Yes, Your Lordship, but the instruction were received were incomplete and were incorrect. Some of the paragraphs.
Speak slowly, speak slowly.
The instruction we received were incomplete and some of the paragraph were jumbled up. So it's difficult for me to.
When did the person retire?
on March 2019, Your Lordship.
Till now, no pension.
No, it's not pension, Your Lordship. It's a delay in payment of gratuity, Your Lordship.
Gratuity.
Yes.
Yes, Mr. H. Abraham, on behalf of respondents number 1 to 4, submits that the affidavit on behalf of these respondents will be filed at both of the day. Submits the instructions have been received. The same needs some examination. She prays once allowed 2 weeks time at last opportunity to file affidavit. Just thereafter.
Hello, please.
Item number 9.
I'm praying for time allotted in this matter.
Yes, for the 2 weeks time that allowed for the affidavits.
10,
Lordship, I'm praying again for respondent 1, 2, and 3, Lordship.
May I
I'm
please
praying
your
for
Lordship?
time. I'm praying.
Lordship, we served the notice for respondent number 4. It's returned to take step. The press.
Mr. H. Karmi submits, he'll file a course of the day.
No, Lordship, I am praying for time to file the affidavit. 2 weeks time, Lordship.
Mr. H. Karmi, in behalf of respondents
1, 2, and 3.
3 praise bonds allowed for the 2 weeks time to file affidavit stuff. MS submitted by the petitioner that it is clear also by the they be allowed to take fresh steps on the respondent number 4.
Yes, Lordship.
Praise allowed in this list after 2 weeks, yes. For affidavit for service report on respondent number 4.
11,
My lord, the respondent 4 has received the notice on 29th August.
How do you say that?
I traced it.
You traced it? How did you trace it?
From the postal website, India Post.
India Post?
Yes, ma'am.
Yes.
Your Lordship, I'm praying for time on behalf of respondents 1, 2, and 3. We're awaiting instructions.
Yes, MS City now brief 1 to 3. The evidence would place we allowed for the 2 weeks time to file. As it place allowed. Stop. Next to the Big Bora submits that the respondent 4 has been served on
29th August,
on
it
29th
was received.
as per the status received. Yes. It's after 2 weeks. 2 weeks.
Yes, sir.
Yes.
For affidavit for appearance of respondent 4.
Obliged, Your Lordship.
item number 12,
May it please your Lordship. Lordship, we have taken over. Now we are operating, your Lordship. We have complied with the order passed by Lordship in the earlier occasion, your Lordship. And from today, your Lordship, there's tourists.
Yes. What's for today?
My lord, so far as at the ground level, the protesters have cleared, my lord.
We have cleared whatever.
And the society have taken over, my lord.
We have taken over, your Lord.
Yes. Now, so far as the miscase is concerned, my lord, they have filed miscase for impleading certain person. And on last occasion, my lord, I have
Do you
raised.
have objections or they are all right?
My lord, so far as the only slight objection is to the fact that they are claiming to be the representative of the clan.
So that's the only objection you have.
Yes, my lord.
Now,
Otherwise, for in pleading, it appears, my lord, from the pleading itself, it appears that they are the leaders of the group. But so far as their claim is concerned that they are representing the clan, it's slightly misplaced, my lord, because so far as Buam clan is concerned, recently, my lord, on Monday, on the 9th of this month, they had a general meeting and they have clarified, my lord, that this person who's petitioner number 3 in the miscase, he is not the representative.
but who is he?
He's just a member of the clan, and the clan have also categorically stated that all his act of protest is his individual act and that of his family. So, my lord, my humble submission is that let them be impleaded, and so far as the claim as to being the representative of the clan, let it be dealt by district council. The locus, let it be decided. That issue be left open for district council to decide.
Lordship, I just want to file one small affidavit, Your Lordship. There are some documents you would like to bring on record.
No, we will not.
Your Lordship, because even we have a dispute with regard to the Buam clan only, Your Lordship. They are saying that they are a representative.
Buam clan is a huge clan.
Yes, Your Lordship. There are two groups, exactly. There are two groups in the clan, Your Lordship. They are representing one
Are
group.
you the right Buam clan or the left Buam clan?
That is for district council to decide, Your Lordship. But then what I'm
That's why,
saying
my lord,
was,
so far
Your
as
Lordship,
this,
there are two groups
so far this
within the
issue,
Buam clan.
my lord,
So one group cannot represent all of us, Your Lordship. They let them represent their group, will represent our group, Your Lordship.
My lord,
Within the clan itself, there is division.
Within the clan, there has to be a clan meeting and decide who
Yes,
represents
but
the clan.
that meeting, Your Lordship, we were not aware. It was held on Monday. So we'll just like to file a small affidavit, Your Lordship.
white publication has.
Held, you see.
Yes, my lord. If my lord can
Your Lordship, because-
come to my affidavit, my lord, I've already filed my affidavit.
Yes, instead of being High Court, become like the Panchayat Darbar.
Yes, my lord.
Yes.
My lord, I'll just take, my lord, to paragraph 5, my lord, of my affidavit.
Yes.
It says that with regard to paragraph 1 of the petition, the deponent vehemently denies the same and the petitioners are put to strict proof of the claims made. It is stated herein that there is no authorization from either the Surong, Sumer, Kriam and
No, no,
Buam.
with two of them you can't.
Yes, yes, yes.
Only with the applicant.
Yes, yes, my lord. Yes,
Kriam
my lord.
and
No,
Sumer
Only
clan.
Guam and Sumer.
Yes, my lord. Buam and Surong, not Sumer. Yes, my lord. Respectfully petitioner to present them. In fact, the Buam clan has held a general meeting on the 9/9/2024 at the hall of Thangbuli village, and it is specifically resolved in the said meeting that that so and so, who is petitioner number 3 in the present case, is not the representative of Buam clan, and that they have chosen so and so as the Kini representative of the clan.
Shamalang Guam.
Yes, my lord. In fact, the Buam clan, before having the general meeting on 9/9/2002, have given a wide publication of the date of the meeting through the local web portal like so and so and Khasi local daily newspaper Nongsan Hima. The said information was communicated to the Lingdor of the Right Buam White letter dated 10/9/2024, along with copy of publication, resolution, and photocopy of the said meeting. My lord, I'll take your lordship to page 6 of the annexure, my lord. With your permission, my lord. It says, it is addressed to the Lindor and Secretary. It says, I undersign hereby inform you respectfully that the Buam clan, Raj Buam, has held its general meeting on so-and-so at the hall of so-and-so, and a wide publicity is given about the said general meeting through the information published by the web portal so-and-so and Khasi newspaper so-and-so. In the said general meeting, the clan have unanimously chosen the undersigned as the Kini of the clan, and the clan also wishes to inform you that so-and-so is not the Kini of or representative of the clan, and the protest at Karangsari is his individual act and that of his family, and is not of the act of the clan. This is for information to the representative of the Rajbuam. And my lord, page 10 is the resolution, my lord. Lord, in this it says, in the general meeting held today, the 9th so-and-so of Buam clan Rajbuam at Thangbul village, Sri Chimpang was chosen to preside over the meeting. The members of the Buam clan with one voice unanimously resolved to reject the claim of so-and-so as the representative of the Buam clan Rajbuam. From the part of Buam clan Rajbuam is hereby to the unanimously chosen Sri so-and-so as the Kini of the Buam clan. The Buam clan hereby authorize so-and-so as the Kini of Buam clan to represent the clan before the government authorities or court. Further, the members of the clan have unanimously resolved to declare that the protest that happens across is the individual act of Tumpang clan and his family, and it's not the of the clan as a whole. This is signed by 337 people, my lord. All the adult.
You didn't attend the meeting, why?
Your Lordship, he was not aware that the meeting was held.
publicity
And
has
this
been given?
resolution also was passed in his absence, Your Lordship.
Why
Here,
publicity?
Your Lordship, what I'm saying is that there are two divisions.
Present, it's past his absence.
Listen, Your Lordship, I may make a small submission, Your Lordship. There are two divisions within the clan. They are representing their side, Your Lordship. There are other Buam clan also, Your Lordship, who are not with them.
That we cannot do.
My lord, if I may,
Your Lordship, and moreover, Your Lordship, the correspondence, the meetings that were held with SDO also, this petitioner, Your Lordship, he was present, Your Lordship.
Okay,
Letters were
fine.
issued
What
by
to do with this?
the government.
my lord, if I may take,
Yes.
if I may take, my lord, to paragraph 10 of my affidavit, my lord.
Yes.
It says this, Your Lordship, that with regard to paragraph 6 of petition, the deponent states herein that the respondent has no objection for implement of the petitioners as respondent in the petition in their individual capacity, as it appears from the pleading made in the petition.
That will be settled by.
Yes.
But you can please the resolution or before the council.
Yes, that they are the leaders.
Capacity, they will call them.
Yes, ma'am.
They will
That they
call
are the,
that, what's his name?
they are the leaders of the group.
Objected to one lang. No.
However, the respondent strongly object to the claim,
Your
and it's
Your
left
Lordship.
open to the district council to decide, my lord.
Your Lordship, in all the meetings that were held prior to the institution of the
We're not going
writ,
there. We're not going there.
even
We're not going there. We're not going there. It's just that.
Let the district council decide, my lord, the issue of locus also.
To the application. What's the other name? An affidavit has been filed today by the writ petitioner to the application for implement Miss case number 162. Okay, wherein materials have been annexed to show that for the Buam clan, a certain representative has been selected. However, it's also been submitted that at this stage, the writ petitioner will have no further objection to the impediment of 1 and 3, only the condition that they have to establish a locus in the proceedings before the district council as and when they occur. So, in this view of the matter, therefore, the rules are Surong and sorry.
Surong is petitioner number 1 and
the applicant number
1 and 3.
1 and 3 shall also stand impleaded in the main petition and shall be arrayed as respondent number
11 and 12.
11 and 12 respectively. This case concludes. In the main case, this court by order dated 5/9/2024 had passed detailed orders with regard to the formulating of modalities and SOP with regard to the operation management of Krang Suri tourist spot as submitted by had passed detailed orders on the modalities also as per suggestions submitted by the Deputy Commissioner. So, it is reported today by the learned at Assistant AAG that the
Lordship, now we have started operating it.
The district administration under the district, what's that called?
District
tourism what?
Tourism Promotion Society.
Under the district administration, right? The district tourist promotion society has since taken over the management of the said tourist spot and things are functioning smoothly. It's very submitted. The protesters who create disturbances have also
removed,
not removed, have also vacated the protest site. In view of the developments, an order that this matter reaches some closure. It is directed that there is no direction here with the council, right?
Noted.
It is directed that the parties, the writ petitioners, as also the newly impleaded parties, and the newly appointed and the appointed representative recently, and any appointed representative by the clans shall raise their claims or counterclaims before executive committee or the one member.
Let it be before the two-member lordship, because if
Executive committee, well,
committee lordship,
Executive committee of the GHEDC.
And the right also be made a party. The right also be made a party.
Yes, writ petitioner.
Yes, ma'am.
Writ petitioner, as the newly implemented is before the executive committee, who shall then take up the matter and dispose of the same after hearing all the parties and give them adequate opportunity to adduce evidence if necessary with regard to their claims for ownership with the tourist spot.
Your Lordship,
Yes.
it's my humble prayer, Your Lordship. It's not only the concern is not only with regard to Krangsury. It's the entire administration of the
Whatever
land, Your
you
Lordship.
you can put it there, yes.
Your Lordship, you may be allowed to file
You file whatever up to them to
documentary.
reject. Yes, on the such representations and petitions being filed before the respondents council. The same shall be examined on its merits and in accordance with law. And also taking the customary practice.
Yes, my lord.
Yes, Your Lordship.
And,
In
my lord,
taking, but then they have to do it. Taking account of customary
They will do it, your lord.
Definitely.
After all, discussing this, the
So we
custodian
keep
of
it
the.
pending or we will
time frame, my lord.
we'll keep it
Let it
pending.
be closed, your lordship, the writ petition. Let the writ petition be
Will
closed,
be
your lordship.
under-
If any party is aggrieved by any decision taken by the executive committee, then they are at liberty to approach again before your
Expecting that
lordship.
the entire proceedings should culminate within a period of 6 months from we give a date for appearance of the parties
Yes, Your Lordship. It's my humble prayer, yes.
from the parties who are put to notice.
Well, that may create some difficulty because it's a multi-member committee.
Oh yes.
So, my lord, what we will do, well, we will issue notice to the
Yes.
respective parties, my lord. And only one aspect, who will be the true representative of which clan, whether that.
No, that you will take it up there. You let them, but there's no should be no breaking of heads. That's the only thing.
Yes, Your Lordship.
That is what we are concerned. Well, that liberty is given to us, my lord. to-
It's all no. No. Before that. Shall we examine and what else? Something else there. Examine. Yeah, before that. Yeah. I can't get the thing. Puli. Alright. It's not good practice. Stop. It is also corrected that the executive committee of the council in the conduct of proceedings shall also you want to ascertain the how do you ascertain in the council? That's the only problem.
Lordship, in fact, lordship, the civil code would be the.
No, Your Lordship. No,
Council will decide.
Lordship, regarding the custom, what is the custom, your lordship, because evidence will have to be.
Then that means your district tourism province society will run the thing for 20 years.
Lordship, we are amending the account, your lordship. We are not taking their money, we are amending their account, your lordship.
No. See, to address the problem regarding we will confine it to those people then who are here before the court, and the ones who brought on record by the
petitioners.
What about Surong Clan then?
Surong Kalan also there's no clarity. The last occasion, my lord has directed them at least to bring the authorization, which they have not done.
Your Lordship, that's why, Your Lordship, I was seeking for time to file my affidavit because the affidavit filed by them, Your Lordship, I had just received it yesterday. So I want to file small affidavit, Your Lordship, to bring on record the authorization. Your Lordship, it's my humble suggestion, Your Lordship, that let the authorization be filed before District Council, Your Lordship.
This court only wants to define the parties who will appeal before it. So there won't be, any confusion that.
Your Lordship, let the authorization be filed.
Like every that Boam clan having, suddenly how many branches,
Let the authorization be verified by the district council.
We will file, Your Lordship. We can file the authorization before this council.
Before district
You
council.
file it by tomorrow.
Tomorrow, Your Lordship.
Let be filed before district council, my lord.
We can file it before this council, Your Lordship. The authorization.
You're fine. It is further directed to avoid multiplicity of proceedings. Only the parties who present therein and also the person set to present a Boam clan as given in the affidavit filed by the petitioner shall be parties to the proceedings.
Your Lordship, what about the respondent, Your Lordship, Mr. Tempang Mawan?
Which one?
The impleading applicant, Your Lordship.
Yes, all of them.
Number 3.
Parties, we already made parties.
All right, Your Lordship.
Yes. Before the district council is. That was also, it is also further noted that it's necessary before the proceeding commence that the district council ascertains the authorization which have been provided by the respective parties to validate their authorization, to validate their
authenticity,
their status as representatives of their clans. Yes. What else you want to say?
That was the main concern.
Yes.
My lord, from our part.
Also, we issue notice to all of them,
Yes.
within 15 days.
The executive committee thereafter, the secretary committee, next paragraph, shall issue notice to the parties within 15 days of this order, and it is expected that the proceeding be completed as expeditiously as possible, preferably with a period of 6 months from its commencement.
Lord, my humble prayer, if some direction be given to bind respondent number 10 to 12, their group, my lord, that do not disturb the management anymore, my lord, in Krangsuri.
Your Lordship, after the last order of the court, Your Lordship.
This to add, till the matter is resolved, till the matter is disposed of by the district council, by the executive council, the direction as contained in the order dated 5/9/2024 are to be strictly complied with.
Outline.
Yes. Matter stands disposed of. And then in that main case again, right, as in view of the order so and so, it's 1 of 12. That applicant in this case something we added as is 1 of 11 12 can reflect the final order. Yes.
13.
May please, Lordship. Lordship, I pray for some time to find my affidavit, Lordship.
Smaller number.
6. Yes, Mr. H. Karan today.
Lordship, may I have it on Monday or Lordship?
How much time?
Lordship will file by tomorrow, Lordship. If the matter can come up on Monday, Lordship, then.
I'm entering appearance, my lord, on behalf of respondent number 5.
Who's 1 of 5?
Look, the other candidate who is granted.
Okay, first, Dr. Mr. I'm saying Dr. Mr. Philanambri entered appearance on behalf of the respondent number 5. As such, notice is complete.
And my lord, I may be permitted to file my affidavit during the course of the day, my lord.
We praise for. He submits that affidavit on behalf of the respondent file will be filed in the course of the day. Stop. That will be H. Karwanam on behalf of the respondent 1 to 4. Also praising out some more time to file affidavit. Only just a matter of the 1 week. Affidavits to file meanwhile. The order passed earlier shall continue until next day.
Highly obliged.
Second call, item number 5.
Yes.
Well, this can be disposed of, my lord. Only amount that
he wants to know the exact amount. To
My
the
lord,
Maya Paisa, how much he is to.
my lord, they are only entitled to 13,500 family pension, my lord. All other amounts were already paid to him when he retired, my lord. He retired some 40 years back, my lord.
40 years back?
My lord.
I am not asking, my lord, any other
40 years back, how old are you now? 120?
My lord has passed away, my lord. His wife is claiming now.
2020, my husband passed away. I am not claiming anything because I submitted earlier that I do not have any other dues, lordship, except the pensionary family pension, lordship. Only the family pension. And the order is very clear that because without.
They are entitled to 13,500 at this moment, my lord, monthly pension, family pension.
If they give, my lord, if they give the details, lordship.
This is the 30,500.
13,500 per month, lordship.
Then what do you want now?
My lord, if my lord will kindly see, because otherwise, lordship, for me, no problem, lordship.
You want a computation of the entire amount due?
Lordship, yes.
That's already accrued to you.
Yes, Lordship.
After 2020.
Yes, Lordship.
You calculate by yourself.
No, calculate because there will be difference, Lordship, because that
How will be different?
every year that there is a rise, Lordship.
You can't expect the court to do all the work.
And my Lord, if my Lord will see 372 of the Succession Act, Lordship, provides that we have to give the details, Lordship. Otherwise, I do not have any problem, Lordship.
It's a recurring benefit. That means that it regards everything. It's not a question of future.
Even if they can give for only for 1 year also, that is the due for so and so to so and so. Still, I can.
You will calculate by 12. I think this exercise
Cancel by
can be done by anybody.
But the order, Lordship, will kindly see order, Lordship, that to furnish the details.
We thought that details are other term benefits.
I do not have anything except that.
This pension, you take this pension.
Then Lordship kindly then make an observation in the event that I approach the concerned authorities, then competent court, they can consider my application for succession certificate, Lordship.
You know, how is family pension, even succession, what did they write? They don't even write the amount. They ask for, they see return benefits than to the family pension or so and so, which is,
My Lord,
that's all they write.
My Lord, had there been
Succession given that, okay, fine, they are entitled to thermal benefits and the family pension of rupees so and so per month.
My Lord is right. Had there been other retirement benefits, Lordship, left by my deceased husband, then I would have, Lordship.
It's for purposes of calculation of stamp duty.
Here only, yes, no problem. Here only the family pension, Lordship. Because there is no other dues, Lordship. Had it been some dues left my deceased husband, then I would have so and so and family pension.
Now are you insisting on succession certificate?
And in fact, Lordship,
But there are claims for two wives.
there is no first wife has already died, Lordship. My Lord, if my Lord children is one judgment, Lordship, the issue has already been decided whether family pension is a death and securities or not. I'll just place my Lord. After that, my Lord can pass any order, Lordship. I'm not pressing. Even if they give me the details also, for me, no problem to obtain the succession certificate. I can go, Lordship.
You obtain it. What judgment to place?
That for family pension, that succession certificate is not needed, Lordship. Because this is not a death and securities, Lordship.
Yes.
So I do not have any retirement benefits, except and except the family pension, Lordship. Lordship will find para 6, what is the issue, and para 11 is the issue, Lordship, para 11.
Let's go to your petition. Since when you entitled family pension? Where is that?
He died on, Lordship, 23rd August 2020, Lordship. And 372 very clear the debt and securities. If there is no debt and securities, Lordship, I'll place one more judgment, Odisha High Court, Lordship.
We already agreed to that, so.
My friend is going to further comply. Then he has to file a suit to establish that it's his wife. A declaratory suit.
Yes, the instant witness application, this case file, right?
This case, Lordship.
Was for direction to supply the details of the family pension to enable the writ petitioner to file for succession. Communication has been produced by the Learned DSGI showing that the communication dated 29 June 2024 has been produced by the DSGI showing that the family pension payable to the petitioner is rupees 13,500. Next one, Mr. S.A. Sheikh, however, submits that the amount as given will not suffice for the purposes of applying for a succession certificate, in as much as a quantitative amount is necessary. So, do we have any submission to make? Dr. Muzika submits that as the amount, the recurring feature of the petitioner's liberty to compute on his own accord as to what is the entitlement due from the date, or what the entitlement, what be the entitlement due? What will be the entitlement from the date it has become due, that's the death of the husband of the petitioner. According to this matter is disposed of, allowing the petitioner to compute entitlement at the rate of rupees 13,500 from the date the CM became due.
My lord, only one observation.
No
In the
observation.
event that the competent court can consider my application.
Competent court, we don't. Yes.
Hearing?
We've had enough of latitude.
My lord.
Hearing 14.
We take this back.
So this is the case again, Afroza Begum, Afroza Khatun. Let's say page number 19 regarding the appointment of the Afroza Khatun. Because this is the second round litigations. First round I came for the non-payment of salary. This is also petition file with a prayer. The prayer is only very simple prayer that I was not paid the salary with effect from May 2021 till date. 21, I'm saying 21 means before that I was getting the salary. It was stopped. It was stopped because of the reason that there was a change of managing committee, which I've enclosed with my rejoinders. The managing committee was, new managing committee was funded.
Yes.
Okay.
New managing committee was constituted on on 12/10/2021.
What?
On 12/10/2021. This is the managing committee because one Mr. Tawfizuddin.
Oh, wait. Yes.
One Mr. Tawfizuddin Ahmad. It was new managing committee was constituted on 13/10/2021.
Now, this order 19 says what? In condition of its order something resolution.
So after the committee was constituted in 21, they have stopped my salary.
So this is 18/9/18.
18/90 is my appointment, showing that I am a sanctioned teachers.
Okay.
Language teachers.
Yeah.
Before that, there was one Annexure 13. In Annexure 13, Annexure 3, page 13, in my petition, I was sworn as a teacher representative in the school.
Afroza Khatun.
It's a teacher,
right.
teacher representative. Now, as per the...
This is the managing committee for terms with effect from...
Yes.
Right.
Now, as per the Annexure 4, page 14, there are three persons, because there are three sanctioned teachers. One is a Afzal Haq, he's a headmaster. Social studies was Hachima Mumtaz, is a science teacher, and the Afroza is a language teacher. Before also the salary was stopped, but I came before the High Court, I got the relief. Pursuant to the order passed by this court, they started paying the salary. It was stopped only in my rejoinder affidavit, Annexure B. This is a managing committee constituted wherein one Mr. Tawfizuddin Ahmad was appointed as a headmaster.
Mr. Joinder filed when?
It was filed on 17 October 2022. I filed this rejoinder. First, Proceedings wanted to remove this Afzal Haq. Then Afzal Haq also filed a petition before this honorable court. This is some interim order also passed. But now, he is the one who created a problem and stopped my salary.
You appeared with Afzal Haq also.
Yes.
You seem lawyer of Afzal Haq also.
No, Afzal Haq I appeared, yes.
Then?
Afzal Haq is one of the teacher, sanctioned teacher. He was a headmaster, social studies. So Afzal Haq was removed by Tosufuddin Ahmed and he became the headmaster of the school. Who? Tosufuddin Ahmed. He became the headmaster of the school. As per my rejoinder, the Managing Committee orders, it is Annexure B, page 73. Here it is shown that Tosufuddin Ahmed members, conveners, means he is the headmaster. He becomes only the headmaster can be a convener. Then he becomes the headmaster. After his conscience committed, then he stopped my salary. For that reason, I filed writ petitions that I did not get the salary with effect from May 21 till date. The salary was pending. Because they don't get every month, they get lump sum amount. Maybe the sanction came after the October's, it was not released. Now, government filing affidavit, government has not clarified in the affidavit. At the first instance, when the affidavit was filed, government was very silent in the affidavit. Government did not say anything in the affidavit. Like government, this is filed by one Victor Smosters Nombek. I don't know the affidavit. He has not said anything in the affidavit. Like who are those sanctioned teachers?
Okay, just to be clear. Okay, Mr. Rishi, go try to understand. Now, this teachers of 2018, correct?
18.
And then at that point of time, there was a committee also ran till 21.
21.
So till 21, you were considered a sanctioned teacher.
As sanctioned teacher?
Yes, and then you were paid a salary.
Salary.
Then after 21, you stopped.
They have stopped.
What does this official then do?
They have stopped the salary without intimations because
what is the role of that official then is saying?
So within he became the headmaster, secretary in the committee.
Then who took your post?
My post is not taken by anybody because Tosufuddin Ahmed is claiming to be a social studies teacher.
That if not taken by anybody,
but there is the thing. The government in the affidavit has not clarified. In the first affidavit filed before this court, government did not say anything who are those sanctioned teachers. Not even one single amendment made here in the affidavit. Then after that, when the government was silent, not indicating who are those sanctioned teachers, then I took the permission from the court. I filed RTI. I got the information from the RTI, which I enclosed in my rejoinder.
This rejoinder?
My rejoinder, which I filed before this court on 17 October 2022. In the rejoinder,
how many rejoinders you filed?
I filed on one rejoinder. So this is the rejoinder which I filed. This is my later RTI informations which I showed.
Where is it? Which page is it?
Yes. The page starts 14. You say 13, 19. With reference to the subject cited above, I am directed to furnish herewith the information sought by you under RTI Act. In this regard, you are hereby directed to correct the information from the office. This is the information which is given to me. Here in the information, it is showing that the sanctioned teacher, I am the sanctioned teacher, just bottom of Rosa Khatun, sanctioned teacher, language.
And then non-sanctioned Tofuddin.
Tofuddin, non-sanctioned.
So he's eating a salary.
He is eating the salary. Until date, he has not produced.
He is headmaster.
Headmaster.
How is headmaster? How will he be non-sanctioned teacher and headmaster?
He is a non. Then I enclosed the paper. He was a fourth teacher, in fact.
4 teachers. And there also his, the second annexures which I enclose, this is a letter issued 2017, page 21 in the rejoinders. It says, as per the teachers' attendance register, acquaintance or roll of teachers and the complaint, SMC, the President Secretary, Sri Tosafuddin Ahmad, is 5-year, no teachers,
Is a
4
5-member
teachers
teacher.
already approved as SSC norm, so that the provisional approval order so-and-so is cancelled.
So he never challenged this.
He never challenged this.
But he continued then after he became headmaster.
Yes. No, what he did,
Teacher number 5 becomes headmaster.
5 headmaster. What he did, there is no such order issued by the government.
So he is an unapproved,
Unapproved teacher.
Teacher number 5
Yes.
was headmaster.
He's the teacher number 5 years. There is no such averment made because
My Lord, I am representing managing committee. And
What about
my
official?
Lord,
Are you representing him?
That issue was raised by during the course of the hearing before also, and my Lord was permitted me to file the affidavit in respect of the Hussein.
What case is that?
In this case only, and I filed the affidavit on 30/10/2023 to
What do
bring
you
on
say?
record the additional documents.
Yes.
On 30/10/2023.
What is the false documents? 1817.
No, Your Lordship, I have in respect of the Hussein, I have brought on record this.
Where is that affidavit? 29 March 23.
30/10/2023, I filed the affidavit.
3010.
3010.
So confusing that it's yes.
This is, Lordship, it will be clear from here.
Yes. Appointed as assistant teacher of primary school in 2002. And what are the new sections? 17 what happened?
And if here one is the appointment letter.
Or wrongly cancelled.
Yes,
Then?
Your Lordship. And then again it was cancelled, that cancellation order revoked. And
Where's the
Your Lordship,
coverage or vacation to cancellation order?
yes, in page 20, all the sanctioned teachers have been reflected by the block machine coordinator, page 20. You see no Puja Kapil.
So this undated also. Page 20, annexure 1.
Yes, Your
J.
Lordship. This is communicated through providing letter at annexure 1, 19, page number 19. On 3rd October 2020. And all the teachers, Your Lordship, they are getting direct salary from the government in their account.
Yes, Mr. Hazarika, what is this? Then where's Afsarza Khatun disappeared from this list?
My Lord, one more
If you're duly appointed 2018, then how can they just disappear? And if it's very confusing, a lot of manipulation here also.
Yes.
As usual in all these schools.
And my Lord, she has not
With
been
due
serving in the
respect,
school
yes.
also.
That is a different
She's not coming to school since 2019.
Right, paid 2021.
And see, because of the High Court order, I was not there in the as a party. Because of the High Court orders, payment was made by the government.
Now the admitting that the salary was paid to me.
And I was not there in that case party.
Only after Tosafuddin, he took over the charge in the managing committee secretary, then he stopped me going to school.
Before that,
because he's, now he's controlling the school. The only question is that I was appointed, approved by the government, and salary I was receiving from the May 2021, they stopped my salary. How I disappeared from because there is no cancellation order by the government.
That's exactly the question is for the court. How did it disappear? It is that's what you put the question. You're duly approved teacher. How did it disappear from the committee of sanction teachers?
yes, Lordship, I have also mentioned in my affidavit that approval order, it was not genuine. When the relatives
But
of
then
the
it's not genuine. What action was taken and
We have-
how was it recalled?
yes,
Where's that?
Your Lordship, we had issue so cause also, and after that we have terminated. That action we have taken.
And termination approved.
Your Lordship, she was not sanctioned. She was just teaching in the school.
Even then, if she's appointed, if that is Is it the fake sanction letter?
Yes, Your Lordship.
I mean, approving her.
Approval.
Is a fake approval.
Yes, as clarified by the approving authority itself in the affidavit we have annexed.
Lordship, in this case, what happened, the court has taken serious view, saying that if it's a fake order, then you make inquiry and submit. Then they said, it is not my duty to make inquiry, it is the government who will make inquiry. Then court has given opportunity to government to make an inquiry and submit the report. Then the government said, no, it is not me, it is the managing committee has to make inquiry. So the matter is over. They are not stressing on the matters. But the fact is that when I was appointed by the government, there is an approval order. If there is a cancellation order, then there must be a cancellation order. But RTI also, I have filed RTI, just still I am a teachers. They have got some RTI from the block development officers saying I am not the teachers. So one set of officers saying I am a sanctioned teacher, others saying not a sanctioned teacher. They have obtained the
But
RTI.
the fact remains that you're not in the picture. You're not being paid.
Because they made me disappear from the schools.
Maybe disappear from
I disappear and they submitted. Recently, Tasubudin Ahmad obtained a RTI from the block development officers, and that was placed by the government before the court saying no, as per this RTI report, Tasubudin Ahmad is the sanctioned teacher. So he said the information given to me by the officer, I am not a competent officer. The officer giving RTI to them is a competent officer. I don't know, they are fighting among themselves. Who is the person to be, correct person to decide. Only the mission district coordinator is the person, so he can decide.
So the official then, that earlier letter of cancellation, how was it wrongly given?
He was, Your Lordship, his appointment was approved prior to her, originally in 2016. When the relatives, her relatives
cancelled it then?
Then again it was cancelled when their relatives came. I'm not aware. But when in the managing committee, the petitioner's relative came, then he was out. And thereafter again his appointment was revoked, or cancellation was revoked. He was appointed prior to the petitioner. So manipulation from their side.
Yes, Sarika, what is your role in conduct and all this, in these proceedings?
Yeah, my lot of simple thing is that they are praying for the salary.
It's not simple at all. The guys of salary, what has happened is like a can of worms.
No, that is not there, my lord, because
it's not there. It's not there. A person is appointed. The sanction letters, a sanction teacher comes for his court, gets an order, pay a salary being paid. That means in recognition that then the other person files the petition. You are same lawyer. What did he want there? Against the
removal of headmaster, because the person was removed from the post of headmaster.
Afzal Haq file.
Yes, Abdul Haq
He filed against headmaster.
Headmaster.
But then he was never headmaster. Then Tofish, okay? Tofish then he becomes the headmaster. And one order shows the fifth teacher or fourth sanction teacher. Who's who? That means now for that post, Tofish eating the salary of the petitioner. The petitioner and they say you haven't come to work since 2019. What is the court to do? It's all on these kind of facts. How do we decide? And if they say that that consent order has been withdrawn, and you get the RTI from the BDO, who is the correct authority to get RTI from?
Lordship, in the consolidated affidavit, Mr. Hazarika filed, he said the district mission coordinators, he is the only person, officers, may make an inquiry into the matters and submit a report before this court.
The district will have to have someone else.
Yes, maybe.
Yes, Ms. Zarika.
Yes.
Who is the competent person to do
I am going to my affidavit, my lord.
And who is the competent person who shall
distribution coordinator
will appoint to
distribution coordinator, my lord. Tura.
Not Tura. Yes.
Dadangere.
Tura.
Tura, my
lord.
No, Dadangere is the joint distribution coordinator, my lord.
To do it.
Yes, that is deputy commissioner.
Joint distribution coordinator.
No, deputy commissioner.
We'll ask the EDC to do it.
Yes.
Because we can't adjudicate the matter.
No, matter will be clear, my lord. If I read out my consolidated affidavit in para 8, my lord,
The
What
matter.
does it say?
Yes.
It is in fact not a considered affidavit. They brought the additional facts on the by way of affidavit. And here in para 9 is saying that the officer who has given RTI to me is not a competent officer.
Why are schools in these areas like this only?
In every school.
Every school
In
have
Garhwal.
high-tech cases. No, from this Plains district.
Plains British. Because the officers are also not very honest. They are also giving you different reports. Some in my favor, some are in their favor.
Giving
Because the information should be
one extraneous consideration.
the information should be based on the official records. That instead of producing any records, they simply give file an affidavit without enclosing any documents.
Even in this case, there are 9 affidavits filed. 9 affidavits.
9 affidavit file, yes. 9 affidavit file.
The respondents, how many affidavits they filed?
The government at the very outset, the affidavit file could have clarified who are those things in teacher, matter would have been finished. But the government did not say anything about the sanctioned teacher, who are those sanctioned teacher. The first affidavit government has not filed. And private respondent filed an affidavit saying that the approval given to me is a fake. There is a bold stand there taken. And after that, said, what inquiry you have made? There is no inquiry you have made. It's the government who will make the inquiry. Government said, I cannot make the inquiry. The reason and why they are not suppressing the fact. Not.
No, the things that can't be decided here, this matter. This is the official of the party here, he's a party.
He's a secretary managing committee. He's representing the managing committee.
No, I've been party by name.
No, by name is no party.
Why?
By name is.
But he's the.
Why? No.
He's the managing committee.
You see, he is the person standing over here getting salary or declaring himself sanctioned.
Yes.
Correct? Then,
very later stage we came to know about him. Earlier, after filing the affidavit, then we came to know that.
chairperson convener was the official then only.
Yes.
Of the school.
Of the school, yes.
See, your petition is very blank also. No?
Yes.
Really claim for salary. Yeah. Reasons, unknown reasons.
Because there's no other issues involved here, no controversies. Simply.
Big controversy.
Now, after the affidavit filed, then a controversy started. When they start denying my approval letters, that I am not a teacher. And my appointment also, they say is a fake. Then controversy started.
In that same date, my lord, 2 order has been passed by the Joint District Mission Coordinator, same memo numbers. But in the one approval, 3 teachers, in the other, they have shown 4 teachers.
Where is that same memo number? Yeah,
Yes. Yes, same date, same memo number.
Where is that? Let's see.
It is in my affidavit, my lord.
Filed on?
Consolidated affidavit, my lord.
What consolidated affidavit?
Yes. Picture.
On 4/4.
Yes.
162.
You see. rejoinder.
Annexure 1.
Yes. Annexure 1, page number 14, my lord.
Annexure number?
Annexure 1, my lord, page number 14 in my
Okay.
conciliated affidavit.
And the same memo number, the other letter, where's that?
Yes, here is, shall I read out, my lord, that order?
No, to read out. You see the same memo number.
Yes, 17 January 2017.
Same memo number.
Same memo number. Here is then another one, my lord, coming in.
This is called a criminal case. Yes. Yes.
No, see, to clarify this.
No, wait. Same memo number, same date. Where's the other letter?
Yes.
I'll see.
It is here, my lord. That is this one. Then type copy of 16. Then it comes. Page number 16, my lord.
The type copy.
No, this type copy is the front side is 15 is the original, my lord.
No.
That is not legible properly, but it is.
See, no, 16 and 14 are the same. 14?
Mine was 18.
14
is the same.
Annexure 1 and
Yeah.
Annexure 2 is 15.
15.
Which is not visible. Type copy is 16.
See this in this.
Yes, my lord. Here is memo number JTDMC in page number 14, DSSA APPT TR oblique 2017 oblique 1712-15 dated 17 January 2017, my lord. And page number 16, my lord. JTDMC DSSA PPT TR 2017 1712-15 dated 17 January 2017. In one to approval 3 teacher, another is 4 teacher, my lord. And moreover, this joint district mission coordinator has got no authority to approve. That is our stand, my lord.
But Afsar Khatun appears in both the letters.
Yes.
So what purpose will it serve? I won't pass. I'll think about it. Yes.
District mission coordinator in my rejoinder I have already stated. He said the letter which appointment letter
Yes, let's go further hearing. I'll pass order the next date because I'm going to go through the file. Very highly confusing.
16.
My affidavit is 8 and 9 para, my lord. I am relying on this one.
Let's go further after one. We'll pass orders. I'll just go through the file. Up to T. Yes, Mr. Jha.
Malo, this is that appointment due to.
Yes, Mr. Chulai.
Lordship, we have no role, Lordship. Only to Lordship was pleased to ask as to whether that we have a list of OBC here or not, Your Lordship. So far, our instruction is concerned, Your Lordship. We do not have, Your Lordship.
Yes.
My lord, the state government is saying that they don't have, my lord. They don't have a list of OBC, my lord. However, my lord, in 2023, my lord, the other districts are issuing the OBC certificate, my lord. How it can be, my lord, contrary?
You give the letter of that. You have given the letter of that from the Director of Social Welfare. You got a copy?
Lordship, yes, we have.
Give him a copy.
Yes, we have already given to Mr. Jha. Also, we have given Lordship the copy.
How? Where is the OBC?
My lord, on the top itself. For recruitment in central government of India. is recognized as a backward class.
You've seen this?
I've seen them.
So should I see this?
Latest answer.
I think, Your Lordship, this cannot be, Your Lordship. When the government sees that it doesn't have the list of OBC.
My lord, I will file a additional affidavit to
Let
that.
them
I
file.
will
Let
bring
them
on to
put by
court,
an
my lord.
affidavit. Your Lordship will
Give
see.
him a copy. This is because this is a certificate. See, it's not a communication. This certificate has been given. Take down though Mr. Anishulai had produced documents on an earlier occasion showing that there are no notified list OBCs
of OBC law in the
state of Meghalaya, and has also annexed, also produced a report of the central list with regard to OBCs, where in the column against Meghalaya it is shown as 0, comma, Mr. Arjha has produced a certificate of OBC dated 21/4/23, which was issued by the Office of the. This is the blank. It's not.
Lordship,
Issued
yes,
by the
I'm very doubtful of this, Lordship.
Subject Magistrate, the Rangere Silsab Division.
Lordship, if Lordship kindly see some in the middle, executive, subdivisional magistrate, executive, I think this is completely a new.
Mr. Should I take instructions? How is it possible?
Cannot be possible. It's not possible, Your Lordship. The letter issued by the.
No, we get it. We get that. I know it. Yes.
Lordship,
after 2 weeks. Yes, it's not possible.
I don't think the government can.
Certificate taken on.
Have a copy of this.
17.
Lordship, well, habit section, Your Lordship. Highly apply, Your Lordship.
Disability. Is disability is one? Disability.
Disability pension. Lordship.
Yes.
May to Lordship. Lordship, before I come to the fact of the case, Lordship, I humbly submit that my claim, petitioner's claim, are covered by division bench judgment of this Honorable Court, Lordship.
Covered?
Lordship. Lordship, I have submitted a compilation, Lordship, on 26 July 2023, Lordship.
Or dated?
Compilation dated 26 July 2023, Lordship. Lordship, has it, Lordship?
2 o'clock. 2 o'clock. The matter will resume at 2:15 for hearing. Yeah. No, it's 2:15. The other hearings of 2:15 resume. If they,
Your Lordship, if I may pray for passover of item number 18, conducting counsel have to leave, Your Lordship.
who's acting counsel?
Mr. SN.
You have to leave.
Yes, Your Lordship, some personal matter.
In that case,
No,
17.
This matter has been pending some time. It's 18.
Passover for a week, Your Lordship.
Passover for a day. Adjournment for a week.
Adjournment, I apologize. Adjournment for a week, Your Lordship.
Hajong.
Yes, Your Lordship.
No objection.
No objection, Your Lordship.
18 1 week. Okay.
Average, Your Lordship.
Yes. Only your matter.
Lordship, I think 25, Lordship. I'm praying for passport.
You ready?
Till Monday. I don't have the instruction.
What 25?
No matter where he has resigned,
yes.
I have a copy of the order.
We'll close it.
If I may just make a 1 minute submission, Lordship. Here, apart from the appointment of this particular person who has resigned, we had essentially paid for a fresh selection process. Neither has it been.
No, my Lordship will look
If
into
I
the
may,
prayer.
please,
Nothing else.
If I may finish, Lordship, yesterday also I had given enough time to my senior to ask.
Regarding what?
That policies matter at church.
I don't know why these.
Why you bring all this?
If I can just submit for 1 minute, Lordship, then he can make it.
Lordship, my only prayer is that it will be taken up on Monday for two reasons, Lordship. Number one, the petitioner is from Pondicherry. We have communicated, he is yet to receive the instruction. I don't have the instruction. And secondly, Lordship, it's Mr. Day's friend, so he also wants to argue in person.
He's Mr. Day's friend.
Kindly have it on Monday, Lordship.
What difference in Monday is? As the petitioner said to be Mr. Day's friend, the request will be made that the matter be posted on Monday, though it appears to be contemptuous. We recorded that since he made submission since his friend.
Lordship is
Yeah.
Only number 17 is left one. No, the one.
17.
Lordship, Mr. Pandey's matter.
Likely matters.
The other matters there also are. What items remaining? Number 24. Yes, your case only, Dr. Mojika, you for the petitioner.
It's 7.
Yes, he's ready.
Yes, Your Lordship, I'm ready, Your Lordship.
24.
And 27.
Yes, 27 years there also.
I'm not there. Mr. Devnath.
I'm date 27.
You ready?
Ready.
Then with C215.
7.
A24. A24. Yes.
May it please your Lordship. Lordship, in this instant matter, Lordship, this petition is a prayer for grant of disability pension, Lordship. Lordship, the brief fact of the case is that the petitioner was enrolled in Assam Rifles, Lordship, and during the course of the training, Lordship, he was sent to P9 Gorkha Rifles in Banarasi, Lordship, and during the course of training, he suffered an injury. And that injury was attributable to service, Lordship, and quantum of injury was fixed at 40%, and he was invalidated out of service, Lordship. And at the time of invalidation, he was...
When was it, invalidation?
It was in 1989, Lordship.
89 is invalid out of service?
Lordship.
Yes.
And during... when he was brought out, Lordship, he was told that he will be receiving his disability pension, Lordship, but then nothing came about. Then finally, Lordship, in short, Lordship, in the year 2020, Lordship, if Lordship will kindly have my writ petition, Lordship.
Yes.
Writ petition, page number 43, Lordship, the type copy would be in the subsequent page, 44 with Lordship. Lordship has it, Lordship?
Yes.
May I read, Lordship? I'll start from paragraph 2, Lordship. On scrutiny of service records of a client, number so and so, recruit/general duty Dharampal Singh, it has been revealed that he had sustained injury, fractura tibia fibula third RT during night parade while attending basic training at 39 Gorkha Training Center, Varanasi. His injury was declared attributable to service conditions, as he was unable to complete his basic training and unlike to become an efficient soldier due to his injury, was brought before an invalidation medical board as recommended by a specialist, Military Hospital, Allahabad, and accordingly invalidated out of service with 40% disability on 1/4/1988. He had rendered a total of 02 years and 19 years days service as a recruit. It is intimated that your client's number so and so, Dharampal Singh, is eligible for grant of disability pension in accordance with the percentage of disability suffered by him is certified by the medical authority as per Central Civil Services Extraordinary Pension Rules 1939. All persons of Assam Rifles, those who were discharged from service due to disability, are being shortlisted. In the same case, are being taken up to the competent authority for the considerations, Lordship. To respond this first, they had affirmed that he is eligible, Lordship. Then subsequently, Lordship, they took a U-turn, Lordship. And Lordship would kindly have page number 64, Lordship.
Yes.
Type copy would be on the facing page, Lordship, 65.
Yes.
Refer to you later number so and so, Lordship. Paragraph 2. It is intimated this number so and so, Dharampal Singh was enrolled in Assam Rifles on 12th March 1986 and discharged from service on medical ground with effect from 1st April 1988 after entering 02 years and 19 days of qualifying service. As per the CCS EOP rules, the percentage of disability would not be less than 60% for grant of disability pension. Whereas as per invalid medical board, processing disability of a client was assessed 40% only. It is intimated that as per Central Civil Service Pension Rules, minimum 10 years service was required for government servant to be eligible for invalid pension and pensionary benefits, whereas he has served only 02 years and 19 days in Assam Rifles. However, documents for issue of admissibility report for grant of disability pension were forwarded to Pay in Accounts Office, white letter so and so, but has not been returned by Pay in Accounts Office, Assam Rifles, later so and so. In view of the above, your client is not entitled for grant of invalid disability pension as per existing position, Lordship. So they turned around and rejected my claim, Lordship.
Yes.
Lordship, their claim of 60% minimum percentage is unfounded, Lordship, and by their own admission, Lordship, in their affidavit, Lordship, which the union have filed.
18 August 22, what's this?
Lordship?
What about this page 76 of the petition?
Lordship, this is with regards to jurisdiction, territorial jurisdiction, Lordship. We had agitated before the Allahabad High Court, Lordship.
76 of it petition.
76, Lordship.
Yes. Last page.
Lordship. As per Rule 3 of CCS EOP rules, the disablement should be attributable to service. And as per Rule 9.3 of CCS EOP rules, disability should not be less than 60% for grant of disability pension. Whereas as per invalid medical board proceedings, disability of your client was assessed at only 40%. Now these rules have been amended and 60% clause stands removed. Right DOP and PWID note number so and so, dated 10th June 2022. Which shall be effective to the person who has been medically boarded out from service with effect from 1st January 1996, Lordship. Herein, Lordship, they admitted that anybody who has been boarded out with disability.
Now, see, now if he had been boarded out of service after 96, that means he would have been given the benefit of his disability pension.
Lordship,
Correct?
Lordship.
But the very fact, the only thing that you're seeking now, he was boarded out in 1986.
Lordship.
So whether in that's own consideration, I think.
Lordship, Lordship, I'll try to satisfy Lordship.
Yes.
Lordship
No,
with regard to that.
satisfy. That's only consideration whether why she not be given. Yes, where's the affidavit? What does it say
Lordship.
there?
Lordship, but kindly come to page number 53 of the affidavit filed by the respondent, Lordship. Next on 9.
Yes.
May I read, Lordship? This is a clarification given to Lordship, the Assam Rifles, Lordship. This is from Para 2, Lordship. After examining the above, it may be stated that at no stage the rules provided that disability pension will not be admissible for disability of less than 60%, Lordship. So there is no such rules that which fixes disability at the minimum 60%, Lordship. And Lordship, I had submitted, Lordship, that this I am covered by Division Bench judgment of this Honorable Court, Lordship. May I take Lordship to that judgment, Lordship? I filed my compilation, Lordship.
Number? Which one?
Lordship, would kindly come to page number 24, Lordship.
20?
24, Lordship.
Satyanarayan?
Satyanarayan, Lordship. Herein the Honorable Single Bench had allowed the disability pension and the Union had preferred an appeal against that order, Lordship.
Yes.
May I read, Lordship? I'll start from paragraph 2, Lordship. This appeal has been filed against judgment in order dated 22 April 2014, passed by the learned single judge in WPC number 214 of 2013. Whereby the writ petition was allowed while holding that since injury suffered by the respondent petitioner was attributable to service, he is entitled to get disability pension under the Central Civil Services Extraordinary Pension Rules. It was also directed to pay the disability pension to the respondent writ petitioner within a period of 4 months from the date of receipt of a certified copy of the order. The fact of the case is that the respondent herein, number so and so, Satyanarayanan, was enrolled in Assam Rifles on 12th March 2004. He was informed at the time of his enrollment into Assam Rifles by the presiding officer of the recruitment team that in case he is found unfit to become an efficient soldier during the course of training, he will be liable to be discharged from service. An undertaking signed by the respondent herein to that effect at the time of his enrollment states that certified that I am aware about the facts and that in case of my being found unfit to become an efficient soldier during the course of my training, I am liable to be discharged from service. I do not enjoy any privileges of government servant till attested rifleman. The above has been briefed by the presiding officer at the time of my enrollment, Lordship. Lordship, I will directly take Lordship to para number 5, Lordship, which would be relevant to our case, Lordship. Upon enrollment in Assam Rifles, the respondent hearing was put under training at number 1 Training Battalion Assam Rifles Training Center in School Dimapur for basic training. While he was undergoing the basic military training, he had sustained injury, fracture neck of femur, LT, within bracket OPDD, and was referred to 151 Base Hospital, Guwahati, Assam for further treatment. He was operated at 151 Base Hospital. The medical specialist placed at the respondent hearing in low medical category A5, which refers to the severe derangement of functional capacity and renders a person permanently unfit for duties. Accordingly, he was discharged from service on medical grounds with effect from 30th April 2005. Lordship. Lordship. Lordship, here, Lordship, I would pray that Lordship would kindly see para 7, Lordship.
Yes.
London single judge, while referring to Rule 3A, 1A of the Central Civil Services Extraordinary Pension Rules, has held that under the rules, injuries should be suffered by the claimant in the service, and thus it should be attributable to the service, and only then the claimant would be entitled to get the disability pension. Learned single judge has also referred to decision taken by the Government of India regarding the disability pension by the revised pension in respect thereof, which became effective from 01/01/1986, Lordship. I have annexed this order, Lordship. The revised provisions would regulate the disability pension and extraordinary family pension under CCS extraordinary pension rules. Below the provisions, a note has been appended in Rule 3.2 of providing that for lower percentage of disability, the monthly pension shall be proportionately lower. Single judge has also observed that Rule 49 of the CCS pension rules 1972 only provides for an amount of pension, and it is not relevant to the entitlement of disability pension, which is to be dealt with separately under the CCS extraordinary pension rules. Thus, the requirement of qualifying service of 10 years as mentioned in Rule 41(1) of the CCS pension rules 1972 would not be a condition precedent for grant of disability pension under the CCS extraordinary pension rules. On this premise, learned single judge has held that respondent herein is entitled to get the disability pension under the aforesaid extraordinary pension rules. Being aggrieved from the judgment, the respondent in writ petition, the appellants herein, namely the Union of India and others, have preferred the instant writ petition. It is submitted that though the respondent herein during the course of the training sustained injuries and thus the disablement is attributable to service, yet he is not entitled to the claim the disability pension for the reason that percentage of disability has been assessed to be 20%, much below the minimum requirement of 60% as per the Rule 9.3 of CCS extraordinary pension rules. He is also not eligible for grant of invalid pension under Rule 49(2)(b) of CCS pension rules because he did not complete mandatory 10 years of qualifying service, Lordship. On due consideration of rival submission, we do not find any infirmity in the impugned judgment. Thus, in Central Service Extraordinary Pension Rules 3A provides for disability. It says that if the disability is attributable to government service, then the claimant claiming the benefits of disability pension can acquire eligibility. In the instant case, there is no dispute that the respondent suffered 20% disability during the course of training. Therefore, he can be said to be entitled to claim the benefit of disability pension. Though a ground has been taken the injury was suffered during the course of training when the claimant was acquiring the competence to perform duty, therefore it cannot be said to be connected with the performance duty. The argument cannot be acceptable for the simple reason that the respondent was found medically fit at the time of recruitment, and that is why he was admitted to training. Besides having knowledge of the requirement of medical fitness for continuance in job, generally no one would perform a feat of the training in negligent manner to suffer serious injury, with debacle of being declared a low medical category. The injury suffered in this case could only be an accidental injury unforeseen by the trainee recruit. At the time of acceptance of respondent for service as rifleman, there was also no note of any kind of disease or deficiency which could have stopped him from completing his training. Another ground that is urged in the grounds of appeal is the undertaking given by the respondent in terms of instructions issued by the Director General of Assam Rifles under policy Decision Rule 3A of CCS Extraordinary Pension Rules, which provides for eligibility of pension in case of claiming of disability. Rule 3A is in nature of a statutory force, and if the same provides for eligibility for pension in the case of disability of lower percentage than 60% is generally acceptable for grant of disability pension under the extraordinary pension rules, then the executive instructions issued by the Director General of Assam Rifles would subserve object of that rule. All the amendments under the rules being in nature of statutory provisions and even also the executive instructions issued by the Ministry of Personnel, Public Grievance and Pensions can have overriding effect on the instructions issued by the Assam Rifles, an organization which is functioning under the administrative control of the Ministry of Home Affairs. Generally, the disability pension consists of two elements, namely the service element and disability element. Service element is equal to the retiring pension based on qualifying service, whereas the disability element is basically attributable to the service. In the instant case, the service element relating to qualifying service would not be relevant, but the disability element which is attributable to the service would determine the entitlement and amount of pension. The appellant organization is admitted that 20% disability is attributable to service. Besides, the Government of India has also clarified the position regarding the entitlement to claim disability pension and has provided certain guidelines for lowering the percentage of pension in accordance with the percentage of disability. The same is reproduced in the impugned judgment passed by learned single judge is reiterated as under. Number 1. Revised provisions effective from 1st January 1986 regulating disability pension, extraordinary family pension under the CCS extraordinary pension rules in pursuance of the government decision on recommendation of the 4th.
Okay, now yes, okay. What will be the percentage then the pension? Proportionally less?
Lordship.
To the basic pay?
Lordship, what has caused this confusion?
What will be the computation like for this disability pension?
Lordship, if I may, Lordship, 50% service element would be 50% of the last paid draw, Lordship. And for the purpose of disability element, what will happen is that minimum for 60%, minimum 60%, 50% disability element will be counted. For 100%, Lordship, I apologize, for 100% disability, minimum 60% would be counted. For less than that,
of the basic
Lordship. For anything below 60%, if it is more than 20%, then it will be rounded up to 50%. No, Lordship, that has been
50%. That means what basic was he drawing that time when he had his injury 86?
Lordship, that basic Lordship will be available with the and Lordship in another judgment of the passed by the Honorable High Court. That competition is
answer the query. So at that time, what would basically be like? How much, Dr. Mojika?
At that one time,
the fourth
1,500 rupees.
Lordship, less than that maybe. Lordship is the fourth.
You get the pittance then.
But Lordship,
but the arrears he'll get from 86. The time he was deboarded from service.
Lordship.
When did you come to court first? After you were when you deboarded from service? When was the first time you came to court?
Lordship, I went before the court with the wrong no jurisdiction, territorial jurisdiction. Lordship, I filed because I am a resident of Kanpur. I went to Kanpur, Allahabad High Court, Lordship. Then the court disposed of the petition on the ground that it has no territorial jurisdiction, Lordship.
When did you file your case for Allahabad High Court?
Lordship, Lordship. '94, Lordship.
94.
94.
So you boarded out 86.
86.
94.
88, Lordship. I was boarded out in 88.
Okay, 6 years after you boarded out.
Lordship. Because I was waiting, Lordship. Because I was.
So 88, then your matter was disposed of in?
94. Then subsequently I filed before the Honorable Division Bench, Lordship, which rendered the same finding, Lordship, that there is no territorial jurisdiction, Lordship.
So the matter before Allahabad Court closed when?
94.
94, Lordship. Allahabad High Court Division Bench. 94, Lordship.
Only.
Lordship.
So after 94, when did you come for this court?
Lordship, I was I presented myself before the responding authorities, Lordship, on multiple occasions, and I made correspondence, Lordship, which I have record of, Lordship.
See, because this puts in the mind of fixing a notional date for when you'd be entitled to like your arrears and pension. But this judgment is substantially covered, Dr. Mojika. It's even dealt with the aspect of the extraordinary pension and with regard to 10-year ceiling that you've imposed. That's the only thing.
My Lord, the Supreme Court decision in Tarsem Singh was given, my Lord.
Yes.
It says 3 years from the date of filing, my Lord.
You did a filing of the petition.
Present petition, my Lord.
Yes.
The second judgment in this, my Lord.
But that's what you only have to. That's the only. You find out what is the basic is drawing that time. If it is a pittance, then maybe we can take it 3 years instead of filing 94.
Well, 3 years from the present petition, but this is filed in 22. From 2019. This is what Supreme Court has said, my Lord.
That's the only consideration the court's having. From when will the pension be payable? Tarsem Singh, where's it? Here in the
Lordship, it is
compilation.
in my compilation, Lordship. Page number 10, Lordship, 10 to 11, 13, Lordship.
Hmm? 10.
Page number 10, Lordship.
Only in the aspect of continuing wrong, because delay and laches.
With regards to continuing wrong, Lordship, I have a judgment, Lordship, which which is there in my compilation, Lordship. State of Rajasthan versus O.P. Gupta.
But because this Tassan Singh puts, he has laid down the law, so that the High Court will, I think.
My lord, in a subsequent decision, if Lordship recollects, there was another matter with which Jha is appearing. So Justice Lokpal Singh,
Himachal High Court.
Himachal High Court.
Yeah.
So that was taken on appeal, my lord. And in the appeal, the pension was reduced to 3 years from the date of filing.
So, but that is the mandate. That all the High Court will restrict the consequential relief to
the period of limitation from the date of filing.
The fine was, what is the basic you find out?
But lots of even in this Himachal matter, the calculation was not done by the court, my lord. It was sent back to determine the amount of compensation.
Was done by the
respondent.
Also, we don't want the court to do the calculation.
Lordship,
but in case it has a dispute, the calculation made by you.
Lordship, if I may assist the court, Lordship.
So the thing is that, see, if it's 50% of, it's a ceiling, it'll be 50% of the basic.
Lordship.
50% normal other pensions.
Which will be very low, Lordship, yes.
No, because normal pension also is 50% of basic.
Yes, Lordship.
But basics are revised from time to time. When the pay commission comes, for example, someone was in 1,000 basic and the pay is revised to 5,000, he'll be brought into 5,000. The last parameter, para 12 of this judgment.
This is division bench.
Division bench.
Between sanction.
Three years prior to the date of filing of the writ petition.
Okay.
Lordship, the present position, Lordship, if I may assist the court, Lordship, I have an except from this EOP rules, Lordship, the present position is, may I please read out, Lordship, disability pension for categories B and C. Normal pension in the rate 50% of the emoluments of or average emoluments received during the last 10 years.
We will do one thing.
Lordship.
We will simplify the order.
Lordship.
Just to declare that you are eligible for SP pension.
The rest of
the rest of when you do it, that's what it'll give you room again to, in case of. So, but then it should be disposed of within. How old is he now?
He is 60 plus, Lordship.
Right.
And restricted to 3 years from the date of filing.
3 years, yes. Anything to say?
No.
Can you submit?
Otherwise, only plea we had is coming to court after 40 years.
No, but it's a
continuing cause of action.
Yes, make a short order.
Right.
Yes, the petitioner before this court by way of the instant writ petition.
But the fact sheet,
Fact sheet, yes.
but it's a handwritten minute, kindly.
Praying for directions to issue the respondents to grant and release the disability pension as admissible stop. Next paragraph. The brief facts are that the petitioner was recruited in Assam Rifles in 12/3/1986, and while undergoing basic training, sustained injuries in his leg on 28/4/1986. The nature of injuries resulted in causing 40% disability, and the prisoner then he was ordered out of service on 1/4/1988 by discharge certificate dated 18/2/88. Stop. The petitioner from the time of recruitment till discharge had put in 2 years and 20 days of qualifying service. Stop. The fact that the injury was caused and the disability was attributable to service conditions is not disputed. And the only contention raised by the respondents is with regard to the entitlement of the benefit of disability pension on 2 grounds. Firstly, that the writ petitioner did not have a minimum qualifying service of 10 years. And secondly, that to be eligible for disability pension, the extent of disability should be to the extent of 60%. So, Ms. S. Pandey, in his submissions, without extensively dwelling on the facts of the case, has submitted that, or in his submissions, has maintained that the writ petitioner is entitled to disability pension in view of the fact that and to support his case has placed the decision rendered by this court by a division bench in the case of Union of India and another versus the Satya Narayan bracket 9. Writ appeal number 57/2014, judgment dated
22 April, Lord.
22/4/2015. The United Council has taken this court through the judgment to show that the case of the petitioner, in fact, being similarly situated to the judgment in question, this court had allowed the benefit of disability pension while discussing the entire aspect. So, next paragraph. Dr. N. Muzika, learned PhD with so and so, has in reply, has submitted that in view of the judgment rendered by this court, the objection that the respondents have is with regard to the delay and latches in approaching this court to seek relief. He submits that the petitioner had been discharged from service as far back as in 1988, and though had sought some relief before a court, which however lacks jurisdiction, has come before this court only in the year 2019. 22. As such, submits on this ground, notwithstanding the other objections as raised, the writ petition is not entitled to any relief at this stage. So, I have heard the counsel of the parties and perused the materials and record, especially the judgment placed by the Red Counsel for the petitioner. So, where's the writ petition? No? Yes, it is to be noted that one of the objections has been raised by the respondents is in the context of Rule 9, bracket 3 of the CCS, bracket extraordinary pension close bracket rules, wherein it is provided that the extent of disablement as certified by the medical authority should not be less than 60%, right? 93 says that.
Lordship, if I may humbly say, Lordship, there is no such rule, Lordship, which has been misconstrued by the respondent.
No, yes.
Then Rule 9.3 doesn't say that, Lordship.
If the government servants board out of government service on a contract investment, and further the percentage is permissibly certified by the authority not less 60%, his money is shall be related to so and so. Or it's only to the extent of pension.
Only to the extent of pension, Lordship.
That if provided that if the percentage will not go there, I think better not go there. We know to distinguish between what is, I understand what the submissions are. Distinguish 60% does not relate to 60% disabled. This does not talk about 60% as being cut off. It talks about if the extent is 60%, then how the extent pension is to be computed.
60% disability is kept at a different footing, Lordship. Yes.
No. I understand what you're saying. What I'm saying is I will not go there because this 60% prescribed, like if it's not less than 60%, then how the pension is to be computed.
Lordship.
That's what this. That is what this one, and it's not the ground that they've set up that he should have 60% disability is incorrect. That is what court wanted to say.
Well, sir.
Ramna? Yes. Wherein it was a, then forget it. Upon hearing the counsel of the parties, from the facts of the case as they pertain, the petitioner had suffered 40% disability. 40% disability, for which the respondents though initially by where the first one is entitled, the later on is not.
WhatsApp.
Do initially by.
This is page number 43 of my petition. WhatsApp.
First one.
First one. WhatsApp.
Though initially by communication dated 18 May 2020 had communicated that the writ petitioner was eligible for grant of disability pension in accordance with the percentage of disability suffered by him as per the CCS Extraordinary Pension Rule 1939. However, by a subsequent communication dated
13 July 2022, Lordship, page 65.
By subsequent communication dated 13 July 2022, however, backtracked on the same by holding that the writ petitioner that the disablement should not be less than 60%. This was followed by an impugned letter, and the impugned letter dated 18 August 2022 with regard to the qualifying years of service, correct?
Lordship.
The qualifying years of service, whereby suspension denied to the petitioner on the ground of his having rendered only 2 years and 19 days of qualifying service. In the backdrop of these facts, and by applying the judgment rendered by this court in so supra, it is noted that the objections as raised by the respondents have no legs to stand on. So, in legs to stand on, certain the relevant go for the paragraphs again. Not noted that the objections of the response have no yes. For the sake of convenience, the relevant portions of the said judgment are reproduced herein. Paragraphs are reproduced herein for the sake of convenience. Next paragraph. Accordingly, under in view of the facts and circumstances of the case, the position of law as applicable, the writ petitioner therefore shall be entitled to disability pension as paid. Stop. However, considering the time taken for the writ petitioner to approach this court for seeking relief of the prescription as given in the case of Union of India and another versus Tarsam Singh, TRSAM Singh, 2008 8 ACC 648. This court deems it fit to allow the benefit of stipulation to commence from 3 years before the filing of the instant writ petition. So, needless to add, the respondent shall compute the pension payable along with the arrears thereon within a period of
3 months.
3 months from the date a copy of order is furnished before the concerned respondent. Matter of only stands allowed in this court of.
D block, please proceed.
Thank you.
24.
So, passing download for you. Yes.
Well, this matter, my lord, the respondent was, while she was serving in ICR on a regular basis, my lord, fraudulently, she started working in NEHU also, my lord, simultaneously. Initially, she was on
at what?
Ad hoc basis, my lord, and subsequently she was regularized in NEHU also. She just changed her name a little bit. Her actual name is Prakash Kaur, and in NEHU she enrolled as Prakaso.
Yes?
Prakaso. So just changed her name a little bit and drew salary from both NEHU as well as ICR, my lord. And in the process, about 25-30 lakh rupees salary over a period of time, my lord, is withdrawn.
25 lakhs?
My lord, over a period of time, 15-20 years.
How long she served?
She served quite some time, roughly 18 to 20 years.
18 to 20 years?
My lord.
Yes.
Now, my lord, CBI registered a case, my lord, investigating the matter, filed charge sheet. When the trial was going on, my lord, invoking the provisions of plea bargaining, my lord, the respondent filed an application. Your lordship, I may take your lordship to plea bargaining, my lord, under CRPC. Now that application is at page 77, my lord. An application under section 265 capital B CRPC for plea bargaining, and basically they wanted, my lord, instant application for plea bargaining may kindly be considered having regard to the old age and deteriorated health condition of the accused person, and further be pleased to dispose of the case in terms of section 265 E CRPC. Now, lordship, the case was charge sheeted under 3 sections. That is, lordship, can see at page 77 itself, my lord, in para 2.
419, 420.
And section 13.2, read with 13.1D of the Prevention of Corruption Act, my lord.
What's 13.1 and 13.2?
I'll just take the lordship. My lord, if I may take your lordship to those CRPC provisions, my lord.
Yes. Yes.
265 capital A of CRPC. A talks about application of the chapter. B talks about application for plea bargaining, my lord. 265C talks about mutually satisfactory disposition. And 265E, my lord, subclause C. It says, my lord, the court can award punishment half of the minimum punishment, my lord.
Where is it written?
Section 265 capital E, my lord.
Yes, whereas satisfactory disposition of the case hasn't worked out.
But the provision will also see. It says, my lord, after hearing the parties under clause B, if the court finds that the minimum punishment has been provided under the law for an offence committed by the accused, it may sentence the accused to half of such minimum punishment. Now, under PC Act, my lord, at page 6, my lord, I have quoted the provision of 419, 420, and 13.2, my lord.
Page 6.
Page 6. My lord, 419 punishment for cheating by personation. There is no minimum prescribed, my lord. The maximum is 3 years. 420 also there is no minimum prescribed, my lord.
7 years.
7 years. But 13.2 PC Act, my lord, it prescribes a minimum sentence, my lord. Any public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 1 year. But
so your case is that if half punishment
of 1
6
year
months should be put behind bars 6 months.
What court has done in this case, my lord? My lord, in fact, there was, in terms of the provision of...
Come by writ petition.
By writ petition.
Why? It's not under 482.
Because CRPC says, my lord, 265 capital G, my lord.
This is new, yes. Okay. Okay, yeah.
The last.
Yes.
The last page of the petition, well, page 83.
The first kind of case I've come across. That's why.
My lord.
Okay.
Page 83.
Yes. Post court. Yes.
But in fact, section 265 CRPC provides for a mutually guidelines for mutual satisfactory disposition, my lord, and it sets out the procedure how this has to be done, my lord. So, in terms of the provisions of the Act, my lord, a meeting was held, my lord.
83, you're reading?
Page 83, my lord.
Okay.
Is the report on mutually
D for mutually satisfactory disposition.
My lord.
Okay.
The accused Prakash Kaur is present along with her counsel so-and-so. Learned PP is present. The accused Prakash Kaur has filed an application under so-and-so for plea bargaining. The accused has been charged with an offence under 13(2), read with so-and-so, read with section 419, 420. In working out mutually satisfactory disposition, the accused was explained about the punishment that has been prescribed for the offence committed by her. The prosecution submits that the instant case relates to cheating the government and obtaining undue pecuniary benefits, and the court may proceed in accordance with section 265 ECIPC, and she may be awarded the minimum punishment prescribed for the offence. The accused during the meeting has admitted that she has committed the offence and is ready to face the consequences thereof, and agreed that she may be awarded punishment as prescribed. This court has suggested that considering the age of the accused and her health condition, she may be sentenced to pay a fine of Rs 50,000 and to undergo simple imprisonment in lieu of the minimum punishment for the offence. Now, this last sentence, in my humble submission, is not making any proper sense, madam. To undergo simple imprisonment in lieu of minimum punishment for the offence.
Yes.
And after this matter, the impugned order was passed. The impugned order, Lordship will see it. Starts from page 13, madam.
30.
13, madam. The operative part is page 22, madam.
Yes.
I'll read from 23 onwards, para 23.
Hmm.
Therefore, having regard to the age and antecedents of the offender and to the circumstances in which the offence was committed, this court is satisfied to extend the benefit of section 360 CRPC to the accused person. The court is of the considered view that the accused, instead of being sentenced to imprisonment, taking into consideration her age and health condition, can be sentenced to undergo simple imprisonment till the rising of the court and released after admonition, and also sentenced to pay a fine of Rs 50,000 only for the offences so-and-so, so-and-so. Order. The accused Prakash Kaur is convicted under so-and-so and sentenced to undergo simple imprisonment till the rising of the court and fine of Rs 50,000 only. In default of payment of fine, she shall undergo further imprisonment for 1 month. The accused is also admonished and released thereafter. So, my lord, our case is, my lord, the minimum that is prescribed under the law.
50%.
50% of 1 year minimum.
6 months should go behind bars. How old is the person?
66, Your Lordship.
Now he's 66.
Yes, Your Lordship.
That's it.
My lord, that is our case. One objection they have taken, my lord, it may be a technical. It was registered as a WP civil, so they have taken one objection. They should be registered WP criminal.
WP criminal.
Yes, Your Lordship. The petitioner herein has filed WPC civil, other civil was under the category, whereas the
Doesn't matter nomenclature. It's not a big deal.
technical.
Yes.
And the other objection they are taking that we have agreed to 1 day, my lord. I've taken a lordship to page 83.
Agreement for 1 day. Who are you to argue? The law doesn't allow you to argue.
Law doesn't allow.
Yes. Yes.
That is our case.
Yes.
Your Lordship.
Any case law? Not review the matter today.
I went through one case law of Gujarat High Court, my lord, but it was very aggressive, very offensive. So I didn't take a printout of that.
Aggressive, offensive meaning?
It is saying that it has become a practice in courts in Gujarat that on the plea of plea bargaining, the quantum of sentence is reduced to a ridiculous level, especially in excise alcohol cases, my lord. Imposing fine of 50 rupees on the plea bargaining because there is no minimum prescribed. I'll place that now.
Your Lordship. Your Lordship, if I humbly submit, this case is covered by principle of estoppel, Your Lordship. Here, as my learned senior has pointed out, page number 83, Your Lordship. Here in the last line, Your Lordship, if I may take you again to page number 83.
83?
Yes, Your Lordship. The report.
What's the estoppel?
Estoppel, Your Lordship, because both the parties have agreed to the suggestion of the learned trial court. The second last line, if I may read, Your Lordship. The second last line.
No, but can it be agreement against law?
Your Lordship, in plea bargaining application, when a plea bargaining application is presented, both the parties are heard.
Even, in fact,
So you mean to say that since no objection is taken at that point of time,
Yes,
they
Your Lordship.
stop from raising it now?
Yes, Your Lordship, that is my argument. Your Lordship, even Your Lordship, if I may take you to the second last line of the page 83. The parties have agreed to the suggestion of the court.
Yes.
The report may be placed before the court. Your Lordship, if you look below, the signature of both the accused counsel and also prosecution is there. Your Lordship, also Order 22, Rule 3, CPC, bars, Your Lordship, that if they cannot file any complaint if it is given with the consent. Here, the PP has also given consent to the learned trial court's suggestion.
See, what is this? Simply, they did not apply their mind. Simple imprisonment in lieu of the fine.
Yes, Your Lordship. Your Lordship, even the CPC Order 22, Rule 3 CPC bars, Your Lordship, except for fraud. Your Lordship, here in the entire petition of the petitioner, here it's not written that this report was obtained due to fraud. As such, now the CBI cannot come after a period of 7 months alleging that the trial court has committed wrong. Your Lordship, if I may take you again to the CRP.
Only one thing, it's the punishment in 13.2 is shall. And so if,
No, Your Lordship.
if you read 265 E
clause,
it says it's half.
It's written may, Your Lordship. If I may take you again to the CRPC.
Okay.
Yes, Your Lordship. Section 265E.
May sentence, yes.
Yes, Your Lordship. May, the term may has been used. It is upon the discretion power of the court. So,
Yes. You're right.
yes, Your Lordship. Clause. Clause
It may
C.
means it may give only half what you give
Or
more.
it
Now, what does it mean?
may means
It may sentence.
it may
accused
sentence.
to half only.
Yes,
That means it
Your
may only give you half only.
Or may
instead
not
of
also.
giving the full
It's
sentence.
written may word is used. If it's shall, Your Lordship, then it's a directory or mandatory. When the term
You read it again. After hearing the
After
part of
hearing-
clause B, if the court finds that minimum punishment has been provided in the law for the offence committed by the accused, it may sentence accused to half such punishment.
Yes, Your Lordship.
To half only. That means like the cutoff is half.
But Your Lordship, it may sentence. Now it's upon.
No, it doesn't mean that. It means that it may. It can go down till half.
Yes, Your Lordship. But
It
however,
can go down till half. Not it may or may not.
but Your Lordship, shall is also not used, Your
No,
Lordship.
shall is different. It's after the parties, the court finds that minimum punishment has been provided in the law for the offence committed by the accused. So in this case, shall, right, it's been by given 13.2. So it may sentence accused half. It maybe say, okay, fine, it was 1 year, do 8 months.
Your Lordship, the bare reading of the bare act, Your Lordship.
It
It's,
can go both ways.
but Your Lordship, if it is so, the legislature would have put it shall sentence to half.
No, it may sentence. That means it gives the
Discretion to the court,
the
Your
power.
Lordship.
Yes, up to half you can go down as well. My understanding, they can go down to half. You can't go below to 1 day or 1 hour like that.
My understanding, Your Lordship, my humble submission would be it is upon the discretion of the court, Your Lordship. And also, Your
Read
Lord,
it again. After in the parties under clause B, if the court finds that minimum punishment has been provided under law for the offence committed, the accused it may sentence the accused to half such. It may to half of such punishment.
yes, Your Lordship, may, but the term is used may.
That also, legislature also uses loopholes. Yes.
Your Lordship, I would like to take you to page number 80
Yes.
of the petition, Your Lordship. Upon my application of plea bargaining, the CBI has also filed a reply.
80.
80, Your Lordship. The relevant part would be page 81, point number 6, Your Lordship.
Yes.
if I may read, Your Lordship, that the prosecution is also ready for the procedure of plea bargaining in view of the petition filed by the accused person before this honorable court. Number 7, that in the above circumstances, the prayer of the accused person, Srimati Prakash Kaur, is in the wise decision / judgment of the learned court. Here, Your Lordship, here also the CBI has, it is signed by the head office of CBI, Mr. Vivek Datta. Here in the reply, they have not written to the court that she may be sentenced to so and so. The reply also says that, and also, Your Lordship, main would be report on mutually satisfactory reposition, Your Lordship. Here, the PP has agreed, Your
The
Lordship.
troubles the court is that it's mandatorily 1 year imprisonment.
Your Lordship, I have a similar situated case which I would like to place before Lordship.
Yes, please.
Your Lordship, para 8.
Yes.
This is the facts of this case, Your Lordship. It is quite similar to our case, Your Lordship. If I may read.
Yes.
I'll read with the relevant line, Your Lordship. Line 8 of para 8.
Yes.
Thereby, the accused was convicted to undergo imprisonment for 1 day till the rising of the court and to pay fine of rupees 10,000, and in default of payment of fine to undergo simple imprisonment for 3 years. This is in our case also, Your Lordship. I was sentenced for 1 day rising till the court, and fine was imposed 50,000. In this judgment, Your Lordship, the
What was the punishment in this?
Yes, Your Lord. It is under Section 27D of the Drugs and Cosmetics Acts, wherein the minimum punishment was 1 year and maximum was 2 years.
Shall be 1 year.
Yes, Your Lordship. Shall be 1 year and maximum would be 2 years and a fine of rupees not less than 20,000. In our case also, the minimum was 1 year and maximum was 7 years. Now, Your Lordship.
But the appeal can dismiss not maintainable. Yes, then?
Then para 20, Your Lordship, which is at page 21. Fifth line, Your Lordship. It is only, Your Lordship, have it, Your Lordship?
Yes.
It is only on mutually extending the benefit of plea bargaining in between the complainant and the accused, but the complainant is a gravement of the incident narrated in the complaint, either orally or in writing. But in the instant case, criminal prosecution has been initiated keeping in view of Section 200 CRPC and also Section 190 of CRPC relating to cognizance in respect of criminal prosecution initiated against the accused relating to offences under Section 27D of the Drugs and Cosmetics Act 1940. When the parties had mutually come forward seeking plea bargaining in order to close the criminal prosecution case in terms of the issues emerged in between them for violation of the provision of Drugs and Cosmetics Act 1940, the trial court had accepted the application filed by the respondent/accused and extended plea bargaining benefit, which was also approved by the complainant/state, who was represented by the assistant public prosecutor. In view of the fact that the accused had pleaded guilty and agreed to pay a fine of rupees 10,000 and to undergo imprisonment for 1 day till the rising of the court, therefore, in this petition, it does not arise to call for interference of the said judge. Your Lordship, I am humbly saying that this judgment covers this case, Your Lordship. As such, this petition is devoid of merits, and hence I am praying for dismissal of this.
It's in the judgment. The only thing is that, yes, it's on your petition also, that no, you didn't ask for any. But that may also, it means.
May is, as Lordship pointed out, that is only to fix the lower limit. It cannot go beyond lower than that. It can be 75% of the minimum, can be full minimum. But I'll go through this. The matter continues tomorrow. My lord.
Tomorrow won't have time. I'll just go through also, just see whether it's a. Yes. That's a further hearing.
Your Lordship,
On?
last submission. Your Lordship, in the even to PP also they have not taken any action. The CBI has not taken any action against the PP since he's the one who has signed the mutual
Yes.
disposition.
Didn't take action
If
with
that
the
is
PP.
the so.
But I pointed out it doesn't say anything. It says simple imprisonment instead of or in lieu of
minimum
Or fine. That is worse. He agreed to simple, or or fine.
No, my lord. Pay a fine of rupees 50,000 and to undergo simple imprisonment in lieu of the minimum punishment for the offence. So minimum was 1 year, my lord. So could have been reduced to half of that.
Your Lordship, the PP was acting on behalf of the CBI. So as such, and it is the order this
Yes. Today is 12th.
12th.
Okay. We listen 19th.
19th.
I'll look something. I'll do my own research also.
I'll come with judgment.
That the interpretation part.
27.
Oblige, Your Lordship.
Oblige.
This is the second round of litigation. It's regarding.
What is this?
It's regarding non-promotion also due to uncommunicated ACR launch.
What happened after your review, DPC?
There was no review, Lordship. They had rejected my representation.
Why?
Lordship, I'll straightly take your Lordship to the impugn order, Lordship. The speaking order passed by
You didn't have a review.
No review, Lordship. Lordship, the impugn order is at page 156. Lordship, para 1, 2, 3, 4 are not required, Lordship.
5.
5, Lordship.
Yes.
Now, therefore, in compliance with the judgment and order dated 24 August 2023, the representation of so and so and so and so has been considered by the competent authority, keeping in view the following aspect. A benchmark for the performance appraisal for promotion and benefits under modified so and so has been enhanced from good to very good by Government of India Ministry of Personal Public Grievances and Pension and Training Office Memorandum dated 27 September 2016. Accordingly, the policy has also been implemented in Assam Rifle with effect from 1st Jan for the grant of promotion, and this is not relevant, Lordship. B, Lordship. In the instant case, the petitioner came up for promotion to the rank of Subedar General Duty as his seniority in the year 2021 and in 2022, and was screened by a departmental promotion committee along with his batchmates in the year 2021 and 22. However, the petitioner was found to be ineligible for promotion due to lacking in his annual confidential report criteria, is found to have been graded high, average 5 points in the annual confidential report for the year 2016-17. This is the ACR which I have been denied promotion, Lordship.
Yes.
Whereas to become eligible for promotion, he should have been graded above average 7 points or outstanding 9 points. Therefore, he was superseded, Lordship, it's not suspended, superseded for further promotion. C, on perusal of the annual confidential reports of the petitioner for the assessment year 2001 to 22, Lordship, 2001 to 2022, it has been revealed that he has been graded average 2 points in the annual confidential reports successively for the assessment year 2007 and year 2008, while in the rank of Havildar General Duty, and high average 5 points in the rank of Subedar General Duty in the annual confidential reports for the assessment year 2014-15 and in the end 2016-17. Assessment and grading awarded in the annual confidential reports by officers and reviewing officers are purely based on the performance during the assessment periods. Hence, award of 2 consecutive average 2 points grading in rank of Havildar General Duty and high average 5 points grading twice in the rank of Naib Subedar have been taken into account, which clearly reflects the poor performance of the petitioner. 6. And whereas on careful examination of the entire service records of the petitioner, it is revealed that the performance of the petitioner during his service was not satisfactory, due to which he was rightly graded high average 5 points by his reporting officers during the assessment year 16-17. Hence, he was not eligible for power of promotion and rightly proceeded for promotion to the maximum higher rank, superior by a duly constituted departmental promotion committee. Now, therefore, in the light of the facts and circumstances enumerated in the preceding paragraph, the competent authority of the detailed examination of the representation of the petitioner dated 22nd September 23 is of a considered opinion that the request of the petitioner to upgrade his annual confidential report for the assessment year 2018-17 and to consider promotion to the rank also lacks merit and substance. Hence, it is hereby rejected as high average points grading awarded to the petitioner in the annual confidential report is purely based on his performance at that time. Furthermore, the performance of the petitioner during the assessment year 2007, 2008, 14, 15 are also below benchmark. This is the speaking order, Lordship. Lordship, while passing this order, Lordship, what has happened, Lordship, I'll take to the ACR grading in which I have been graded. Page 73, Lordship. Page 73.
Yes.
Lordship, just below there's a table, Lordship. 2015-16, 7 points, 7 gradings recommended. 16-17, 5 points recommended. 17-18, 7. 18-19, 7. 19-20, 7. Lordship, this 2016-17, 5.
Yes.
So, Lordship, kindly come to the year 2015-16. I was graded 7 points.
Yes.
So now, subsequently in the next year, I was graded 5 points, which shows there's a downgrading, Lordship. Now, why I have been graded 5? There's no finding in the impugned order. And this 2016-17 was never communicated to me, Lordship.
Never communicated to you?
Never communicated, and that's why I've approached this court, and this court has directed the respondents to forward the entries. Now there's no finding as to why I have been downgraded from 7 to 5 points. And this is an adverse remark, Lordship. Lordship, can we come to the ACR at page 82? Page 82 is the ACR in which I've been denied promotion.
Yes.
This is my ACR for the year 16 to 17.
September 16 to,
16 to 17.
Yes, 1 year.
Ashok, can you come to the next page? Page 85 is relevant.
Yes.
Ashok, just below there's a pen picture, serial number 15. Now this is the initiating officer, Lordship. He has graded me 7 points. And look at his remark, Lordship. Individual is physically fit and robust. He enjoys good command and control over his subordinate and is dependable. Now,
where we're reading?
Your Lordship, page 85, serial number 15.
85.
85, sorry, Lordship. 85.
Yes, 15.
15. Now, this is the grading awarded by the initiating officer. There's a remark below, Your Lordship.
Yes.
Opposite to that is a grading 7.
Yes.
Now, the initiating officer has graded me 7.
But reviewing officer give you 5.
Lordship, I'll come to that, Lordship. Now, this initiating officer had signed this ACR just below his signature, Lordship. Can you see the date? 20th November 2017.
Yes.
Now, 16, Lordship. Reviewing officer, a physically fit GCO who execute assigned tasks with dedication. But the remarks, the grade is 5 gradings. Now, just below that grade, Lordship, he had signed this, RO had signed the ACR on 30th December 2017. Now, point 17, Lordship, the senior reviewing officer. A high average DCO, I agree with the assessment of the RO. The IO is liberal in his assessment, and he has graded me 5. Just below that, can you see the date, Lordship, in which the ACR was signed?
19.
27 August 2019, Lordship. And this ACR pertains to 16-17.
Yes.
This is done belatedly, Your Lordship, just to deny the deny petitioner his right to promotion. How is it done? That is only for the respondents to answer that. Now, kindly come to page 86, Your Lordship. 86, just below, Your Lordship. Adverse weak points in the pen picture, white, para 15 to 16, communicate to JCO in writing, white, which says nil, Lordship. That means 15 to 16, that means the grading by the RO and the SRO.
15, 16, picture.
15 to
picture white, 15, 16, communicate to writing white nil. 15 is initiating officer.
16, Your Lordship.
No,
Rated B5.
White, para 15, 16.
15 to 16. 16 is the RO, Lordship.
But it's signed with initiating officer.
Lordship, 15 is initiating officer.
Right.
16 is the review officer.
Right.
Initiating officer has graded me 7. RO has graded me 5, which is an adverse remark, Lordship.
Right. Down is here.
So as per this ACR instruction, they're supposed to communicate me, Lordship.
But then, by the order, you not communicated. You communicate this.
Thereafter, there was a subsequent, Your Lordship, subsequent event, and they communicated me. But I'm just trying to show how the ACR is managed, how the ACR is.
That we can't go beyond that now. The thing is that now what that impugn order.
Lordship, coming back to the impugn order, yes. Lordship, there's no finding as to why I was downgraded from 7 to 5, Lordship. That is one point. Second point, they say that I lack performance in my service, Lordship.
No,
they never served me any.
That is objective assessment of the. We'll not sit and appeal over the assessment.
Lordship, but then
that the only court's concerned that in the process you've been given adequate opportunity.
Because
that's all.
Lordship,
but to say that to ask for amendments that you should be upgraded, that they've had a review DPC, they've on their representation whatever they have already decided.
Lordship, my contention is that if I lack performance in my service, they should have given me a warning letter, Lordship.
It's not lack performance. It's not.
They say lack performance.
Five is what? 5 is not. It is not a question of see. Okay, let's see what the grades are given.
Lordship.
Like 5 mean how much? 5 will mean.
5 will be, Lordship. 5 will mean. 5 will mean.
5 is a high average.
High average, Lordship.
Yeah. High average is not adverse entry, but any entry has to be communicated to you.
Lordship.
Right.
Lordship,
Good.
that is correct, Lordship.
Yes. Okay, that is not a question of bad entry. It's not a question of adverse entry as such. But any which affects your service career, any entry should be communicated to you.
That is a settled position, Lordship.
By the courts.
Settled position,
That
Lordship.
everything is held that should be communicated.
Lordship.
So that's the thing. So how do you seek to get your your ranking from a magistrate court to be upgraded?
Lordship, my prayer before this court is, Lordship.
You're seeing the fraud. You're not seeing manipulation. That after 17, how will the accepting officer sit in 2019 after 2 years and think and know about your assessment?
Lordship.
And that the thing seems done. Why? What do you mean by it done as to deprive you? Why do you say that?
Lordship, the intention behind all this, Lordship. The ACR is 16 to 17, Lordship.
Right.
There's no occasion for the SRO to grade me in the year 2019. And for grading, Lordship, the person has to be present there, Lordship.
Where do you say that?
Lordship.
Take out authorities.
Lordship. And another aspect, Lordship.
See, it happens or sometimes after it's done by the reporting officer and by the reviewing authority. Somebody comes accepting authority, it takes time also. There are some procedures. Some takes time. So that cannot be, you cannot attribute some, malafide or illegality to that action. It's happened many cases in many departments. Now reporting, he's right he's with the officer only. Reporting, reviewing, finish. When it comes to accepting, which is a much higher level, sometimes at a time the file travels, much time has elapsed. So whether you can attribute this, and you have not changed the 5 has been held, that author communicated to you, right? You came before this court.
I came
then
before this court
later on.
And communicated, Lordship. Yes. And Lordship, the other aspect is that I was graded. They say that 5 points is not an adverse remark, Lordship. Now that is totally wrong, Lordship. I have judgments. Lordship, there's a judgment passed by your Lordship also. Your Lordship is part of that bench as to what amounts to adverse remark in regards to ACR.
So if it goes down, it becomes like an adverse.
It goes down,
if
Lordship.
You don't maintain what you've been given. that is not adverse entry as such, but it goes on. It affects your service.
It affects my service,
your
Lordship.
Service graph, yes.
Lordship.
So that's the thing. That should be communicated to you. That's a given.
Lordship, but there's no finding as to why there's a downgrading. There's no finding, Lordship. They say poor performance, Lordship, and they relied on 2002.
Finding is here says that physically fit GCO who execute assigned task with dedication, but gives you a 5. That is also, we don't understand, but that is objective assessment. Maybe doesn't want to put down something else, why give you 5?
Lordship, if this impugned order is relied on the gradings passed by the SRO, Lordship, I have to examine, Lordship. The ACR signed by the SRO is after 2 years, Lordship.
As per the orders of the court, review DPC was held. I mean, to upgrade the ACR, sorry, rather. Yes.
So this against the speaking order, I cannot make any comment because what's not given there, given in this.
No. What needs to do is submission. I don't see to speaking order.
In the speaking order, it's been considered all his ACR, even including the past with whatsoever.
How do you say that he doesn't have any right anymore?
Here in Lordship, as per if you come to this even page 23 of the petition, and which is given the Director General Sassanway recording instruction number 497, what's was relied upon. And then report here, it is two type of report. In page 24 it is given. Type of report is, these are two types of, one is annual conference report, another is adverse report. So it is not the adverse report.
I don't understand what he's saying.
So you will see here, page number 24, you will see in the writ petition.
Yes.
So here it is stated, you will see that's
24.
The type of report.
Yes. Where reading?
Top.
Yes.
These are of two types. This one is annual confidential report and another is adverse report. So there is no adverse. This is the annual conference. This confidential report, whatsoever was considered for the promotion. And moreover, though he has got the point of 5, but he was eligible, one of the candidates to be considered the DPC, and DPC has considered these matters, and then after this, when he was having the grading less than other the candidates, so that's why he didn't get the promotion. It is not that due to his grading, he was denied even in the DPC for having the promotion.
Now see, okay.
So here even 26
minimum qualifying service, okay, for writing the ACR. What about accepting authority? Don't see anything.
So
initiating
page number 26, you will see. These are the adverse report stated. Plus 31 adverse report. Adverse report on the JSU is initiated in the following circumstances. When the JSU...
No, we're not there at all. This is totally not applicable. He's on a different ground. He's saying that nowhere in the ECR reflects that, why should be downgraded from 7 to 5. If the initiating officer given 7, where there's no reason that, that the initiating officer given 7, he does not deserve it. What is the reason?
And Lordship, the criteria for ACR promotion as regard to from Nayab Subedar to Subedar is at page 22, Lordship. What is the criteria, Lordship? 3 out of 5 reports should be above average. Remaining 2 reports should be below high average. Now, Lordship, while passing the impugned order...
Your case is that, in spite of not being immaterial, it was entered there purposely just deprive promotion.
Lordship.
How can the court discern that?
And Lordship, the other aspect is that while passing the impugned order, Lordship, the respondent has relied on my service period, which is from 2002, Lordship, which is not even relevant, Your Lordship.
It's not relevant.
Not relevant at all. 5 years is more than enough, Your Lordship. And 5 years will be from 2014.
We just referred to them, but then in the final consideration, they did not do that.
And they said poor performance because of from 2002 to 2022, I have poor performance. There's no record, there's no letter, there's no warning letter, Lordship. I'm not even aware why.
What's a tough case in your case? Why? Because after initiating also give you 7, and the reviewing officer didn't find anything wrong with you, but downgraded you by 2 points.
By 2 points, Lordship.
That's it. That is where the crux lies. So now whether that's permissible.
Lordship.
Now he has not recorded anything to say the initiating officer. In fact, accepting officer has said that he's liberal.
Lordship.
Yes, but the reviewing officer didn't say anything.
And liberal after 2 years, yes, Lordship. That remarks came up after 2 years, Lordship.
It doesn't matter, but most important is,
Lordship, that will be arbitrarily, Lordship, because even Lordship may kindly go to the record of instructions which the respondent has relied. Rule 40 specifically says that weak at adverse point has to be communicated, Lordship. That is against
no, they didn't communicate it.
They didn't communicate, Lordship.
Then you were communicated n number of cases.
And then they relied on the same ACR, Lordship, and they denied the upgradation, Lordship. They rely on the same ACR, Lordship.
The only thing they didn't discuss it at all.
Never discuss anything at all, Lordship. 725Y, Lordship, we fail to understand.
Do you have any authorities?
Lordship, there was one case which Lordship was also part of the bench. In that case, Lordship, he was communicated ACR entries for almost, I think, 7 years, Lordship, at once. So he was denied promotion to second in command. We had filed a writ petition before the single bench. Single bench said that you have already been communicated with ACR, doesn't amount to communication. So we came up to division bench. Division bench has held that the actions of the respondents are arbitrary, Lordship, and your Lordship has granted promotion to the petitioner. Though at that time the pendency of the appeal, Lordship, the appellant at that time he had got promotion, but with your Lordship's order, Lordship, he was granted retrospective promotion with that effect, Lordship.
Bring the judgment, where is it?
I have the judgment. A very detailed judgment, Lordship. Each para is important, Lordship. Para 6, Lordship.
It's different footing. Yes, Mr.
It goes back to the non-communication of the ACR, Lordship.
Exactly.
It goes
But
back
then
there, Lordship.
subsequent facts is because you don't
Primarily
not given a chance to represent against the same.
Lordship. But they've relied on that same ACR, Lordship.
Whatever it is, we cannot represent. Yours is a case of a review being done on orders of the court.
There's no review, Lordship.
Not review, I mean, okay, reassessment.
There's no finding as to why the grading should not be upgraded also, Lordship. That lacks.
You bring some rulings.
Lordship, what has happened? The petitioner is now promoted, Lordship, last year. My prayer before this court is for retrospective promotion.
Yes, Mr. Devnath, you're sleeping?
No, he
oh. You get authority, we'll see. I mean, it's very limited. I do not know how we can afford any relief. Because the questioning you have to go, you have lived a bail.
Because they have relied on that uncommunicated ICR, Lordship, and that goes back to the root of the matter, Lordship.
No, you not given a chance. You have represented against it now, after orders of this court,
Lordship.
And they have not said anything about it. That's all.
Lordship.
So your questions only that we have to send it back to them to re-examine, reassess,
Lordship.
and to consider what that achieve. What will that achieve?
Lordship will grant me some time. I'll come with
Try to get
authorities.
authorities. Otherwise, you'll have to come.
That's why we have so many cases, Lordship.
That's why you have to come for third round in litigation. Yes, they'll consider again same thing they'll do. This is on reconsideration. It's not the first blush. That's considered.
Lordship. Obliged.